Good morning, everyone. Oh my goodness, this is loud. Okay, say it again. Good morning, everyone. Welcome to the Board of Behavioral Sciences Policy and Advocacy Committee meeting. Today is October 20th, 2017. The time now is 8:43, and we're at the Department of Consumer Affairs building in Sacramento. Christina, would you please call to establish a quorum?
Good morning. Christina Wong.
Here.
Deborah Brown. Here. Dr. Christine Whitlisbach. Here. Samara Ashley. Here. We have a quorum.
Thank you very much. So it's time for us to introduce ourselves. So we'll start with the staff and the board members and the public. You're more than welcome to come up to introduce yourself, and it's optional. So we'll start with Steve.
Hi, Steve Sodergren, Assistant Executive Officer of the Board.
Kim Manson, Executive Officer for the Board.
Christina Wong, LCSW member.
Deborah Brown, public member.
Christine Whitlisbach, public member.
Samara Ashley, public member.
Christy Berger, regulatory analyst for the board.
Roseanne Helms, legislative analyst for the board.
Sabina Knight, legal counsel.
The public, if you're willing to, if you choose to come and introduce yourself, feel free to come up to the podium up there and speak.
Leah Brew, and today I'm here
Is it
as...
on?
Oh,
Is it
yeah,
not
it's
going-
on. It's
Okay.
just not very loud.
Okay.
Can you turn this one up louder? Is it okay?
Yep,
Yeah,
you
there we
got
go. So today I'm here as an LPCC and also a counselor educator.
Dean Porter, Executive Director of the California Association for LPCCs.
Good morning, everyone. My name is Alon Montgomery, and I'm here representing the California Association of Mayors.
Hi, Sarah Huckle with Senate Business and Professions Committee.
Thank you very much. The next agenda item is the discussion and possible action regarding business and professional code. It's granting of the qualifying master's degree program or doctoral degree and 4999.96D, granting of qualifying degree 90 days rule. And I believe it's Roseanne.
Yes. So the first item today up is the 90-day rule, and this has kind of been an ongoing discussion. We touched on it at our exempt setting committee a couple of months ago, and we're continuing the discussion here today. I'm going to just go over some general background. I think everybody understands the main points of the 90-day rule. If not, feel free to ask. Currently, we have the 90-day rule for our LMFT and LPCC applicants. There is no 90-day rule currently for associate social worker registration. And this year, there was an attempt by a company called Seneca via AB 456 to propose this, but that's now a 2-year bill. When discussing that AB 456 at the May 2017 meeting, the board did note that it had some concerns about the 90-day rule, but it also supports the concept of parity for applicants across license types. So with that in mind, just a little background, the 90-day rule has been included in LMFT law since at least 1984, is what we found dating back to when the LPCC Licensure Act was created. It was modeled after LMFTs and therefore included the 90-day rule. The purpose historically has been to assist recent graduates in obtaining some of their hours during the time they're waiting for their registration number. Currently, the board strives to keep its registration processing times to under 30 days. However, in the past, due to high application volumes, budget constraints, or furloughs, processing time has at times been higher. In addition, before fingerprint processing was done electronically, there was a much longer wait. It could be up to a 3-month wait for the FBI and DOJ to perform their background checks. At this point today, we do electronic fingerprints, and that's typically, the results are gained in about 3 to 7 days. And so when reviewing AB 93, which is the board's supervision bill, the legislature identified a public protection concern about the 90-day rule. And that concern centers on the fact that the 90-day rule does allow unregistered individuals to provide mental health services before their fingerprint clearance has been obtained. We took a look at some data from other states to see what they do. We did not find a 90-day component for any other states, and that data can be found in attachment A of your packet. We did look at a few other boards under DCA and to see how they handle this issue. And other boards each board is set up slightly different in how they process their applications and how people go about getting licensure. For psychology board, you don't need to, when you're gaining your supervised professional experience, it can be gained both pre and post-doctorate. Registration with the board and fingerprinting is only required if you're working in a non-exempt setting. They have exempt settings, which are academic institutions, public schools or government agencies, or via a department mental health waiver where you don't need to be registered with the board or fingerprint. However, those are typically government agencies. The main difference with our board would be that our exempt settings are government agencies, school, colleges, or university, or nonprofit and charitable. So that's kind of the different piece there is the nonprofit charitable. The Occupational Therapy Board, the board does not have post-degree experience requirements. Experience is gained within the degree program under the supervision of the school. There's no registration or any registration with the board while they're in school. So it's all done under the jurisdiction of the school. They do have a limited permit that allows graduates to work under supervision while waiting to take the national exam, but fingerprints are required for that. And then we looked at the acupuncture board. They don't have a registration category for pre-licensed individuals. They only issue licenses, and the schools run the clinics where the students gain experience. So we've kind of been tossing around a number of possible solutions to the 90-day rule issue. We've heard several different things. I've kind of touched upon them in my memo. There may be others that you want to bring up. That's why we're having this conversation today. Some of the possibilities that I've heard or we've discussed are eliminating the 90-day rule entirely, with the caveat that we do have people out there working under the assumption that they're going to be applying, and they're under the assumption that the 90-day rule will be able to count for them because experience hours are good 6 years back. The second possible solution, allowing counting of non-clinical hours only. And so there would be no psychotherapy counted under that. Allow the 90-day rule if the supervisor certifies the applicant was fingerprinted. That's another idea that I've heard. Narrow the window that the 90-day rule applies, so it can only apply for a limited amount of time. We discussed that a little bit at the last meeting. One concern that I have with that is that it doesn't really eliminate the legislature's concern about fingerprinting, so it just narrows the amount of time somebody can count those hours. Registering trainees, which is something that the board did in the early 90s, and it was unsuccessful for a number of reasons. They ended up changing that back after a couple of years. And so I go into the detail on that a little bit in the packet as well. But really, we're just here to have a discussion and see if we can come up with some solutions to this. So with that, I'll open it up for discussion.
I want to thank Roseanne, very, very thorough research, to look at, the other boards and also other states. And it's been an issue that we deal with for some years. So I wonder, any feedback from the board members and staff?
With the proposed options, definitely I would recommend not registering trainees. That's for a variety of reasons. Primarily, historically, we see that did not work. And it would create a fiscal impact because we would need an entirely new unit to strictly register trainees. My other concern with that is when we look at parity on that, if we're registering the trainees, what happens with the social workers? Because not all the social workers won't actually go on to do clinical services. And so that might be an unnecessary burden on them at the start of their degree program, to make them pay for a registration fee and then kind of renew that registration, when in fact they're not even going to they don't intend to provide clinical services. Additionally, if they opt out of that, then what if they change their mind? Now that they weren't registered, they can't count those hours. And so that, it tends to be very problematic. So I'm curious to hear what other options there may be in addition to what we have suggested. Definitely would like to get this resolved if we could.
So, go ahead.
I just wanted to say thank you for giving us the opportunity to participate in this conversation. And thank you also for all the hard work that went into preparing for the meeting. Helpful. Again, my name is Alon Montgomery. I'm representing the California Association of Marriage and Family Therapists today. If I may, I just wanted to do 4 things in discussing this first issue. I wanted to share CAMP's thoughts on the impact of what it would mean if the 90-day rule were eliminated, to review these solutions that were presented in the materials, offer an alternative solution that wasn't in the materials, and to address the Senate's concerns. I know it sounds like a lot, but I'm going to be brief because I know other people have very important things to say as well. CAMPS believes that eliminating the 90-day rule would essentially result in 2 things. The first would be the inability of nonprofit mental health agencies and counseling clinics to provide accessible care to California consumers. The second outcome is potentially the exploitation of specific provider populations who work in nonprofit mental health agencies and counseling centers as trainees and applicants. With respect to the first outcome, many diverse California populations and communities, such as rural communities, low-income communities, immigrant and refugee communities, and at-risk youth communities, like LGBTQ youth communities, rely on the services of nonprofit mental health agencies and counseling centers that employ MFT students and trainees who began their field placement there and intend to remain there through the intern registration application process, as well as licensed individuals. CAMP sees that removing the ability of an individual's ability to gain hours during that 90-day period would ultimately result in the loss of those specific providers at those settings who couldn't sustainably remain there without deriving some type of professional benefit, such as the ability to gain hours towards licensure. Secondly, providers that chose to remain at a site would be doing so without, again, receiving any type of professional benefit, mainly the ability to gain hours towards licensure, which could potentially result in widespread exploitation of that specific provider type who has already extended themselves financially to get to that point in their professional career. With respect to the options, and not in any particular order, CAMP, again, doesn't, with respect to option 5, we were perplexed that was even on the table because it just seems like it would be an unreasonable expectation or task of the board to assume jurisdiction over thousands of individuals. So that doesn't seem like a viable option. with respect to the option of allowing individuals to count non-clinical hours, it seems like that's not viable, being that most of the hours that are gained at those settings are clinical. And it would still kind of prevent those individuals from gaining the hours that they're striving to gain in order to submit their application. Again, shortening the time period from 90 days to 60 days to 30 days, shortening that wait time, seems like it just doesn't really resolve the issue of potential loss of services to consumers, and the exploitation component that could happen to individuals working at those settings. It might be possible for agencies to certify, but again, those agencies would have to be willing to undertake the cost of becoming live scan recipient certified, and that could be prohibitive for some, because my understanding is that there's an administrative cost and security measures that those organizations would have to bear, and so that again could be cost prohibitive. So those are Camp's thoughts about the options. I mentioned another alternative that wasn't listed, and again, I don't have any data or schematics about how this would be executed, but after speaking with stakeholders such as schools and pre-licensees, one option would be to have schools live scan their students. And again, I don't know how that would be executed. I haven't been privy to those conversations, so I wouldn't be able to elaborate any further on exactly how that would be done. We've recognized that the Senate's concern, which is a legitimate one. We want consumers to be protected. We want providers to be protected in the way that they need to be protected. And we think that the best way to do that is to make sure that instead of checking someone at this stage, to do that at the outset, at the beginning, somehow. And so hopefully we can have a conversation around that and preserve the 90-day rule, for the MFT members or applicants. And so really that's all I had. Thank you very much.
Thank you very much. And Leah?
So Leah Brew, and I'm coming as a counselor educator and a supervisor today. I guess I don't see how eliminating the 90-day rule protects the public. There are two sets of students, two ways that students sort of progress. When they graduate, they're done with their agency and they have to look for a job. So I don't really see this as hurting those students. What I see is when students are continuing at their agency, and especially when they have an opportunity to become employed by the agency once they get their intern number, but they usually are volunteering up to that time. Without the 90-day rule, maybe some would stop seeing clients, so that would harm clients by them not continuing on, or they would be volunteering, staying at the agency, knowing that they wouldn't collect the hours, but out of the goodness of their heart, for the sake of their clients continuing on, in which case we're still not protecting the public any differently because they're still seeing the clients. So I just want to make that point, and I also appreciate the importance of optics in politics. In terms of the schools certifying them, our department could not take that on. The idea, well, first of all, we don't graduate every single student that walks through the door. And even when we get to if we were to do it at the time they start practicum, many of them don't make it through because of the way we gatekeep. And many of them actually have no intention of becoming therapists anyway. Like we've had people who are authors and wanted to understand human behavior better, or they worked at a government agency, so doing other types of work, so having a master's degree they would make more money. I'd say, I'm just pulling this out of my hat from talking to students, 20% of students never had an intention to see clients from the beginning. So it kind of feels unfair. They would pay that $60 to get fingerprinted to do that. The second piece is my administrator, my admin person, would have to take on that job of, and we have one person for 200 students, would have to keep track of who got fingerprinted, who hasn't, and then at the end of the fingerprinting, canceling all of that notification that you get, and then we have to take in that paperwork if something comes up, if a conviction emerges. So there's the fiscal piece to the students, there's the administrative piece to the university, and then the financial piece. Right now, at Cal State Fullerton, we are the lowest funded CSU, I'll admit, out of the 23 campuses. However, right now, we're pushed to try to raise money on our own just to run business. We're not even able to do anything beyond the absolute minimum with the budget that we have. So whatever additional costs outside of just taking care of the paperwork, I'm not sure we could afford that. So that, I like the idea, probably great for private institutions who could pass that fee on to the students, and then, but I don't know with the CSUs if that would be possible.
Christine?
So Leah, just tell me a little bit more about the supervision that occurs for these people.
Yeah, so typically, once they graduate, well, first of all, they've been at the agency for a year. So if there are any concerns about their behavior, they have, in our program, this isn't true of everyone, it's a little more rigorous than what the BBS requires. So they have to have one unit of individual and one unit of group. So every week, they're in 3 hours of supervision, even if they only have one client. And we watch video recordings of their sessions in class, at a minimum of 6 over the course of the year, and sometimes potentially 10 or 15 videos of sessions. So we have a sense that even if they have a DUI, for example, because many of our students do have DUIs, they come because they had a messed up adolescence, they got sober, and then decided to come into the profession. We have deemed them safe to practice, and we have a very close eye on them. And my hope is other institutions do as well. And then the agencies are another set of eyes. So once they graduate, then they start meeting the supervision requirements of an intern, even if they haven't, an associate, even if they haven't officially gotten their number, but they start treating them like associates. So the supervision hours decrease, that's true, until they get their, right upon graduation, because it's cheaper for the agencies.
So, did you want to add something to that?
Yeah, go ahead.
Okay.
Yeah.
So, if something were to happen, like in my profession, for instance, when I have an intern, if something happens to them because they're unlicensed, it's my license that's on the line. Is it the same sort of setup?
Yes,
There's
it's the
recourse for it.
supervisor's license on the line, for sure.
Okay.
So my question is that now, that runs very similar to the social work program, that you have an agency supervisor, and then you have a school supervisor, kind of monitoring, the work and the product. Now, when we're talking about counting hours and the trainees, so, and the the continuation of care, right? So I'm thinking now that, are we mixing some of the discussion here? Because, is there a guarantee that, the site supervisor will continue on being their supervisor so that they can meet that supervision, standard, to count their hours? So it's the assumption that, if they sign up, at that nonprofit agency, that, that supervisor will be eligible. And then, the supervisor will be, creating the supervision contract and and all that, even before the school start, or, when they're finish, their internship? I'm just a little confused.
So are you asking, how do we guarantee the supervisor is going to continue supervising?
Now, so the service is one. I understand the continuation of, care. It's very important. And yet, when the 90 days rules, also what it applies is mostly, for the student to start counting their hours. And so in order to count their hours, then you have to have a supervisor agreement and all those things. So how does that happen? At what point it happened, at the student's internship?
Right upon graduation, because they can do that retroactive 90 days, the supervisor has to treat them as if they've already received an associate number. Otherwise, those hours wouldn't count for the 90-day rule. So, yeah.
So you're saying they enter into the responsibility statement of the supervisor? Okay.
Right after they graduate, because otherwise they can't count those hours, right?
Okay.
They have to set it up as if
they have the number.
Exactly.
Got it.
And that puts the supervisor in a precarious position if they don't, right?
Correct. If I may. So then when the trainees are going to the agency, you talked about the safeguards at the agencies. Do you know if they fingerprint the trainees or do any kind of onboarding that kind of provides, because they are in those settings with the, placed in there by the schools. So what safeguards does this consumer have?
So for the government agencies, whether it's the counties or state agencies, they do all the fingerprinting. The 401c3s, 401, 501, whatever that number is. The nonprofits, as a general rule, they don't do that. They barely have enough money to get by. So there is less safeguarding there, for sure. But it's an exempt agency, so they can be doing it anyway with no intention to ever get licensed.
Right. So I'm a student. I'm in your program. I'm going into my practicum. I'm going to go to an agency, let's just say government agency. And so I have my school supervisor. I have my site supervisor.
And you've been fingerprinted.
And I'm fingerprinted at the agency. So they're getting fingerprinted while they're in school anyway.
If they're collecting Medi-Cal, they are getting fingerprinted.
Okay.
Yes.
Okay. That makes sense to me.
So to kind of wrap up my perspective, so on the one hand, there is no evidence that clients are being harmed by doing this. I don't know how it works with social workers. Do they just terminate with their client? Oh, wow. So that hurts clients, which we know. Not long-term damage, but it would be better if they had continuity of care. However, if there is just no way that this bill could pass with a 90-day rule, despite, to me, the evidence that it shows it's better to have it for both the associates as well as the clients. If there's no way, I kind of think we just have to eliminate it and suck it up and deal with it.
So I just want to, give the social work perspective. And I think for many years that for me supervising, MSW intern, it's a really important training, even in the treatment modality that, you have a beginning and you have the end. You don't really hang on to, the client beyond the service that is being, authorized or, can be provided. So it's important for the client to also know ahead of the time, what the limitation, of the length of the services. Or even you deal with, insurance and Medi-Cal and stuff like that, now they talk about the medical necessity. You really shouldn't be seeing the client more, beyond, what they deserve. So I think it's a very healthy habit, and a practice, to terminate a client instead of hang on. And so, and also, the other flip side is that I don't think the social worker the social work professional have hurt any client that with the termination that cause any harm also.
Well, can I ask you something?
Yeah.
So let's say they graduate in May and a new client walks in the door in April. Do they just not take on that new client then? Okay, so what they do is they adjust and they sort of cut off maybe 3 months before they're going to graduate or whatever that magic number is.
And that's a very important part of the supervisor to monitor the caseload, and the case assignment. So, when you know that, you're going to leave tomorrow, you're not going to pick on a new client. So, so I think it's a very dual process, not just the responsibility on the student, not hurting the client, but also the supervisor.
Right.
Because like, we said, supervisor's license on the line. Yeah.
To kind of piggyback a little bit too, just we ran some numbers about applications because currently the social workers don't have that 90-day clause. So the MFTs do, and so when we look at the volumes, we start seeing, for example, this last year in May, just before graduation, we had 208 applications. Then it goes up to 324. In July, we get 461. And then in August, we get 424. So it seems like this MFT students are kind of staggering those applications because they can, because the law says as long as the app is in within 90 days of the graduation date, you can count the hours. Contrast that to the ASWs who get no hours until they get their registration number. In May, before graduation, we get 285 this year. In June, we got 730 applications, and then we get 547. And then it drops back down in August to 312. And so that suggests to me that the social workers have kind of figured that out because they know that we won't give them the hours, and it's one of the reasons we're hot on our we heavily monitor our processing times to make sure that we get the registrations out within 30 to 45 days, max at peak volume. The fact that the fingerprints are electronic, it could be a situation where we already have the fingerprint results in the queue, but once the staff person works that application and says, yes, here's the app, there's the fee, the transcripts here, there's the fingerprint, the system automatically generates that registration. And so once it shows up on our website, that social worker is good to go. As with any of the associates, it's they don't need to wait for that hard copy. If it's on the website, you're legally able to work and start counting the hours. So, I mean, it's with respect to eliminating the 90-day rule, I mean, yes, that is a burden because it's going to affect a big population. And if that is the pleasure of the committee and the stakeholders that we see that this is the only way to go out, I would absolutely encourage us to really consider some type of phase-out process because you're affecting people in the pipeline, and that's unfair, and we inadvertently did that in another instance, and it's really hard to just say, gosh, I'm sorry, you just didn't get your app in on time. It changed this date, you came in 2 days after that, I can't apply the old law. So definitely encourage that. And I would be interested to know more if the schools would be interested in just taking on that role. I mean, I know there's a lot of challenges.
Just a quick question. So looking at your numbers in terms of graduation rates, can the BBS handle an additional 1,000 applications in June?
Yeah.
Okay. Just want to make sure that's really
no,
important,
I mean,
right?
you will obviously move from under a 30-day, around 30-day processing time for those registrations. And keep in mind, we're talking clean apps. We're not talking anybody with a background because they just go to another pipeline. But yeah, I mean, it's doable. I think even in peak season, 45 days max? Maybe if we're fully staffed, 60, what do we do? Right now, we're 3 weeks out.
No, I mean,
Whoa. That's a stats guru over here, so let's figure.
Yeah, last year on our fiscal year, I was just looking that up, for MFT interns, we had 20, the largest one was in May, 33 days, but that was unusual because of staff allocations and stuff. So it's about 19 to 20 days is the most. The highest. I mean, on average, we have 17 days processing, 17 to 20 days processing for the intern applications.
I guess with this information and understanding how social workers have been doing it, it is a cultural shift that will be hard to enact, and I like the idea of making sure the process gives everybody ample time to make those adjustments and changes. It may need a couple years instead of just one. But I would support the removing the 90-day rule. I would support removing the 90-day rule.
So what about the option of counting the non-clinical hours? Because, now the MFT rule also changed, allowing 250 to now 500 of, the non-clinical hours. And that's about 10 weeks worth of full-time work. So, and that would also allow the possibility of, for the client, for the student to stay at their agency, and yet also, pick up some of those hours that, that they can do something, but just not necessarily, on the capacity of, of seeing clients. They can do something other than seeing clients. But at the same time, they remain at that agency and, kind of like, yeah.
I guess camp's concern is really to protect certain provider populations from being exploited. And, I was thinking about this and, I just wonder if, because I talk to a lot of people who are very passionate about the work that they do and are committed to staying at these sites where they're working. And I just wonder what kinds of attitudes it would engender in that person as well as those employers if a person is thinking, I'm not able to, even though I may not be deriving any type of economic benefit or professional benefit, I'm going to stay here. And I just wonder what kind of attitude that engenders in that person, because I think maybe without admitting it, that person feels stuck. And the employer knows that. And I feel like they're already vulnerable. And so I feel like there needs to be some protection to avoid that, to prevent that. Camp's number one goal is to preserve the 90-day rule for that reason. So I just wanted to add that and then add something that Lee said, that there's, as far as we know, there's been no data or no incidents of that specific population, like engaging in criminal activities or having, cause of harm. So I just wanted to add that.
I do hear you. And I just want to make the comment with all due respect. The purpose of CAMP is to advocate for the professional. Our purpose, I just want to remind the committee, of course we all remember this, is to protect the consumer. So I think we're coming from two different perspectives.
Yeah.
And personally, although I understand what you're saying and I have empathy for that, our role is not to be concerned about that. Our concern is consumer protection. So I just want to make that comment.
And I understand. I think we all have an interest, and hopefully the mutual part of that is just making sure that, consumers and providers are protected in the way that they need to be. Thank you.
Any other comment? Christy?
I just wanted to, I was just thinking about this. If we do move forward with eliminating the 90-day rule, why not include the option of allowing agencies to keep the 90-day rule if the agency fingerprints? What would be the harm there? Not all agencies would be able to do it, but some might. So just to throw that idea out there, that but the problem is then you might have two different populations. So you have some people who wouldn't be able to meet that and through no fault of their own, but it's just something that to consider. Some agencies might be able to afford it.
Well, the immediate concern that comes up to me in my mind with that is that we don't know, we're not going to know about those hours until 3, 4, 5, 6 years down the road. And then at some level, there has to be some verification that they got fingerprinted. What does that look like? Is that another piece of paper from the agency that says yes? Is it, is it a form that they submit to us, or we just self-certify? And so I'm thinking about the evaluators, and when they get those avalanche of applications and they're trying to figure out the hours, were those clinical hours that were gained that we allowed before it's just more research on their part. And I get it. Yeah, and I think it might have been Leah that mentioned it's a real cultural change. I mean, we're talking about unwinding something that's been in place for 30 plus years that probably came into place because of the processes at that time, hard cards. We probably had one person looking at applications at that time. And so when they got hit with all of that paper, it invariably it would be 90 days before you got your registration number. But with data that says you get a clean app, they're out in 17 days, maybe less than 30 days in a peak season. It's a little, I don't know, 30 days doesn't seem unreasonable to wait for a number to begin working. I don't know that we could get it any quicker than that, but it just, I mean, it's an inherent part of the process. So that's kind of my comment. I mean, I respect what those agencies do. I respect what the trainees are doing. I absolutely am concerned about client continuity. I just don't know that the 90-day rule gets us there, and then having to apply it across the board when you have to, the lens looks like we're allowing people to practice unregulated, and then consumer protection being our mandate. That's kind of a hard pill to swallow right now.
Is it okay? I would suggest if we remove the 90-day rule, a very aggressive campaign that goes to the agencies to make, maybe even with a flyer or a brochure with a recommendation about how they're going to need to manage termination if it's an agency that hasn't had social workers, also to all the universities, and that the university departments are going to have to advocate. So one of the things that we've done for our students is we have let our grad studies program know you've got to do our applications first because they can't get employed and paid until their graduation is done. So grad studies does our applications first in the university over all the others, and that those are some changes, because sometimes the universities can take 30 to 45 days to get their paperwork done. So it would have to, like putting those kind of suggestions in so that we can advocate on behalf of the future licensee, even though that's not the board's jurisdiction, but ultimately it's better for everybody to have them out faster. So I would say the board should brainstorm ways in which we can make sure those times are as short as possible, looking to social work of what they do for best practices, send that out to universities and agencies.
So I wonder now, so we talked about, the possibility of the phasing out. So, in terms of the legislative cycle, so when would be, the earliest, the implementation of the change of regulations?
My suggestion would be to put some sort of sunset clause on the 90-day rule. My recommendation would be a 2-year phase-in, because it would allow and if we did 2 years, so if it goes in now, becomes effective in 18. So students enrolling in practicum in 2020 or enrolling in degree programs effective 2020, we could put them on notice that doesn't apply, and then that gives us a 2-year window to do the aggressive campaign that we were talking about, and it gives the schools, I think, enough time to shift.
So just want to check something out with you. When they start the program or when they start their practicum, because some schools they start seeing clients right away, and then in other schools they don't see clients until their second or third year.
I would probably say at the start of the program. What do you?
I don't know that we even need to tie it to practicum, because practicum is not when the 90-day rule starts. It would be graduation.
So would it read something to the effect of applications received after ABC date?
Applications received after, so it's 2018, January 1, 2020. something like that.
Something like that.
Are not, so,
I would say we need one more year because a lot of people don't pay attention until the law is actually effective. And wouldn't January 2020 be when the law, it would be effective? I mean, could be the earliest it would be affected, right? 'Cause,
Correct. Depending on how we
19
write
no,
it.
It would be 19, right? January. So
Well-
if it was signed next year.
Right.
If it was signed next year,
Then it's-
if we did 2 years, then
Be
it would be
2021.
effective, it'd be 2020.
2021 would be the
2021 is 2
two-year
years.
gap.
2 years, you're right, okay.
Yeah.
Sorry, my math is bad. Yeah, so 2021.
So it could be effective as quick as 2021. So my thought is, just my experience is people, they aren't going to look at the law until 2021.
Correct.
I mean, and sorry, until 2019. So yeah, 2021, that would give the universities
That
that
extra
1
year.
year cycle to finish up what they were doing, and in that year, start transitioning to the new.
So the transition would begin in 2020, and then it becomes effective 2021. Is that what you're suggesting?
Yeah, yeah.
Okay.
Yeah. Because
And
they
is-
won't look at the law until it's
I
passed.
know.
But if it's 1/1, that's right there in the middle of the academic year anyway.
Well, yeah.
So it doesn't really affect them until they graduate
Well,
in
some
May.
some graduate in December. Some
Oh.
graduate in August.
Right.
What if we did August 20?
August of 2021.
2020, yeah. Because then that gives that, I don't know. We could work.
That only gives them a year and a half.
Yeah.
August 2020 is
It's
only a
just-
year and a half, right?
Yeah, I'd just be clean and do January 2021.
Okay.
Because the people who were finishing their degree plans in fall of 2020, they would have had a year and a half already or 2 years already to know that they can't take on a new client in December.
Okay.
Let me check. Any other public comments? Okay, all right. So Christine, you're ready to make a motion?
Yes, but I
Okay.
might need help with the wording. So I move that we recommend to the board, would it be removal of, elimination of the 90-day rule, with the hope that it would go into effect
Well,
2021.
or the direction to make, it to I don't know, this is where Sabina gets to help us out. A sunset clause?
Would be, I think we're looking at we would recommend a sunset clause for students completing graduate study effective January 1, 2021.
Okay, that's my motion.
Do I have a second?
I'll second.
Samara, second. So any other discussion? Okay, we're ready for a vote.
Okay, just for clarification, can I get that sunset clause date?
January 1, 2021.
Thank you. Okay, here's the roll call. Christina Wong,
Yes.
Deborah Brown,
Yes.
Dr. Christine Whitlisbach,
Yes.
Samara Ashley. Motion carries.
Thank you very much. So let's move on to the next agenda item. I'm looking at the time.
I wonder
Do
if
you
we
want to take a quick break?
I think so.
Let's
yeah.
take a quick 5-10 minutes break. 5? Okay. So the time now is 9:31. Let's come back at 9:36. Thank you. At your seat. So let's restart our meeting. The time now is 9:40. I think we're ready to start the next discussion, which is the AB 93 amendments. Roseanne, please.
Yes, so kind of along the same line as we were talking about with the 90-day rule, we have some proposed amendments to AB 93 that we've been working with the Senate Business and Professions Committee on. we've worked pretty extensively to develop some amendments that strike a balance of preserving the original intent of the bill while making some cleanup to address some of the concerns that the Senate committee had about clarity of certain language. And so the language that we've come up with is shown in Attachment A. It looks like a bill. It's not in print yet. It's still a proposal. We just drafted it that way so that it was easier to identify the proposed changes that the board has not approved yet. Any changes that are being made that are substantive have to be approved by the board in order for the bill to move forward, since the board is sponsoring it. So this is going to be a little bit tedious. I apologize in advance, but there are just a few, there's some really minor cleanup changes that I'm not going to address. We can address that when the board approves the final language, which would probably be in its February or March meeting. But I'm going to go over some bigger sort of concept ideas just to make sure that everybody's on the same page. I think what I'll do is I'll go through the things that I wanted to point out first, and then definitely if the stakeholders have any feedback or concerns that they want to add. Some of the stakeholders, I've shown this draft to them. Some of them have weighed in on anything, but if there's anything that I missed that somebody's concerned about, please speak up after the discussion. So the first item I want to discuss is on page 5 of the bill. And when I talk about the page of the bill, I'm talking about the page number that's on the top of the bill, not on the bottom. Page 5 between lines 20 and 21. And it's under subsection capital A. The language is being changed slightly. Previously, the law has referenced a licensed clinical psychologist. That language is actually not technically correct. That's not how the psychology licensing law addresses themselves. And so the correct way to address that is licensed psychologist. However, somebody brought up the concern that sometimes we get confusion because we license educational psychologists. So the thought was maybe we could make that reference to be something like a psychologist licensed pursuant to Chapter 6.6 of the Business and Professions Code, which would be a reference to the Board of Psychology, not our educational psychologists, who are not supervisors. So any thoughts or feedback about that? Okay, and hearing none, I will move on.
Okay.
Page 6, line 39. So it's in some of the cleaning up of the language, we're trying to make the language more tight and concise and to the point. The Senate committee pointed out that it's technically incorrect on line 39, it says, we're talking about somebody that is a supervisor. It's technically incorrect to say has and maintains a current, an active California license, because the law already implies that the license is a California license. However, it gets a little confusing because the subclause above that one, this is the clause talking about how you must maintain a license in California while you're a supervisor. The clause above it requires, in order to be a supervisor, you have to have been licensed for 2 years anywhere. It could be another state. So we're now specifying that it could be here or in another state, but then when you go and strike that California out, some of the stakeholders have raised concerns about that, so I wanted to have that discussion.
So right now the supervisor, in order to be a supervisor, they can be a California license or out of state.
For the 2 years of so in order to be a supervisor, you have to have been licensed for 2 years somewhere. Right. Here, another state, it doesn't matter. But so we're saying that's clear the way that this is written. But then when we go and say has and maintains a current and active license,
right,
that has to be a California license.
Right.
And so I think the concern on our licensing units end and on our associations end is that, you know, the stakes are a little bit high if somebody misinterprets that. Not that it's technically legally correct to not say California. So I'm just wondering if there's a different way we can reword that.
So it hasn't been an issue, right, for, you know, if we put that active California license. And, you know, if I'm confused now, then I think, you know, the public will be really confused. So would that be easier just to keep the California license?
From staff's perspective, yes.
Yeah.
Because I can tell you the phone call that we're going to get, it's going to be, we're going to deny somebody's hours because the individual did not have a California license. And they're going to point to this section of law and says, you just said license.
Right.
And yes, technically, because the code is a California code, and it is, you know, the presumption is whenever we say license or certification, we're referring to a California license or certification. So perhaps it's redundant to keep California in there, but on the other, you know, in contrast with that, it certainly makes it abundantly clear.
It's clear, yeah.
Because what that call is going to the call will first come to staff. Staff will punt it to either myself, Roseanne, or Steve. We will then generate a call to legal, and then we're going to have some kind of legal response to that individual. And you're looking at a lot of resources to clarify. And I understand the perception that we should probably educate, and we do educate, but even despite our best efforts to educate, the camp's going to get the call, everybody's going to get the call, and it's, I don't know. Yes, we'll educate, and absolutely we'll continue to educate, but I think just from a resource perspective, I mean, this just, to me, appears like it's not hurting anything, it's okay to keep it in. That's just my perspective from the staff's point of view. And maybe, you know, Sabina wants to weigh in as well.
I know we met about this once before, but this particular issue we have run up in legal affairs. I've run it up through senior attorneys and as well as our supervising attorneys. And the general consensus from the legal affairs division is one word isn't going to unnecessarily burden the provision, and it would increase clarity, and they had recommended that it stay in.
Alon Montgomery, California Association of Marriage and Family Therapists. I don't have anything to really add other than to support what Roseanne has said and what Kim has said regarding what confusion that could potentially create, even though that is redundant. And I think it would result in the board having to, number one, exert a lot of resources to clarify something that may be self-evident, but still that doesn't mean that it's not going to be misinterpreted. And God forbid someone submit an application to the board looking at the statute saying, well, it didn't say California. And I can only imagine that that's the last thing that the board would need. And so I don't have anything more constructive to add other than to reiterate Roseanne's position and Kim's position.
Thank you.
Hi, Sarah Huckle with Senate Business and Professions. First, I'd like to thank so much Roseanne and Kim's efforts in this. This is, as you can see by the strikeouts, this is quite an undertaking by everybody, and I appreciate everyone's efforts to bring this statute to greater modernity and particularly clarity. On this particular instance, I understand that legal affairs doesn't think one word is going to kill anything, and this is just part of the broader conversation about this statute. There are principles in statutory construction that transcend just the codes relating to your board. And throughout the codes, if it says license, it's California license. So by putting in California license in some place, thereby other licenses do not necessarily mean California licenses. I understand that there is mass confusion. The statutes in general are pretty confusing, and unfortunately, we don't write them to the lowest common understanding. Just some principles to keep in mind from going through some other revisions in this area.
Thank you. Any other discussion? Oh, hi, Jonathan.
Jonathan Maddox. I am a licensed marriage and family therapist in the state of California, and I agree with what's already been stated. Excuse me?
Yeah, just make it closer.
Make it closer. So I agree that it's important that we have significant clarity, as much clarity as possible for applicants to know and supervisors to know who does and does not qualify. So I'm wondering if the word California is the word of discrepancy, if language stating something like an active license issued by the Board of Behavioral Sciences would actually meet everyone's needs. It doesn't say California, but it's clear that it has to be issued by the Board of Behavioral Sciences, and then it seems like at that point the conversation is as clear as it could be as it relates to the board. Thank you.
Expand on that point, if we were to go that way, we'd have to include the other licensing entities, and I think you could specify that using code sections.
I think we could too. I think we could say as specified in, and I can't find it right at this point, but I think we can work on doing something like that, and I think that's a great solution.
Leah?
Leah Brew, counselor educator in LPCC. So are you saying that instead of putting California, you just put the code? Yeah, I think that would be good, because if Business and Professions Committee doesn't want us to put it in and we can't pass the bill, I'd rather pass the bill and remove the word, right? Because there's so much really important stuff here for public protection.
Yeah.
That's my preference.
And Christine?
I guess the question would be how the committee might feel about Jonathan's suggestion.
That's okay.
I think we've got so much going on in this bill that there are opportunities for compromise on a lot of issues. So I think if you'd like to move this into the category of let's consider this among other issues that maybe not everybody's together on in the first place, I think that's totally fine. So.
So Roseanne, do we need some direction, clear direction about this particular amendment?
No, I don't think we need any formal direction right now. I'll come up with, I'll work with the committee to come up with some language that's amenable to both parties. And then when the board considers the final board language,
Okay, sounds really
you can
good.
weigh in on it.
For this one? Yes. Okay.
All right. Moving on, page 17, line 2. But also this appears in a number of different places throughout the bill. So there was a suggestion that I think is a good one, that we better define what the supervisor is responsible for supervising. And so we settled on the term mental health services. Obviously that term may mean different things to different people. So I wanted to kind of go over some examples of when it is used to make sure that we all feel that it's technically correct in every instance. So in this particular case, we are saying, as used in this chapter, the term supervision means responsibility for and control of the quality of mental health services being provided by the supervisee. That's one instance. Sometimes we've replaced the term mental health services with,
Roseanne, I'm sorry to stop you. We're having trouble finding where you're at.
oh, okay.
Which page?
Page 17.
Top number?
Yes, the
Okay.
top page number, yes.
There's many page numbers on here.
Yes, I know. It's whenever I say the page number, I'm always referring to the very top.
Thank you, okay.
So it's page 17, line 2, which is not right at the top.
Got it.
No, that's okay.
So I think for this particular context, mental health, to clarify mental health, Well, the word mental health, has been used. I think, the addition has been either inserted, to clarify service or replace the word professional. So, and I, jot it down that, this can be, I know that, as supervisor, a lot of the work that we do is definitely, mental health based. And yet there's also some other, categories, say like, when you look at the experience, there are also the category not particularly relating to mental health. And they may or may not count the hours per se or require supervision, but at the same time also encompass, being part of the services being provided, say like, to the social workers. So I would say that I would rather just keep it a little bit broad. If you say the quality of services, it's an understanding that it will be mental health services, or the related services. So I don't know if it's really necessary, to clarify it, or whether putting the word there will actually limit, other than, put more limitation than, the clarification. Christine?
Yes, I don't see it that way. I just see it as a non-issue.
Right. Any other comments?
Leah Brew, counselor educator. Even if they're not necessarily providing psychotherapy in the moment, right, because sometimes we have to do other types of things, it's still in the interest of mental health services, but quite honestly, I'm not attached to it either way. So I don't see it being a remarkable problem, because I think it is within the context of mental health, so without mental health, it's fine, but keeping it in there is fine too.
Rebecca Gonzalez, National Association of Social Workers, California Chapter. I concur with what Christina said. I think that makes sense.
I guess especially for social workers, because it's not just doing this mental health services. Social workers do a lot more than just mental health. So I would say that, it might not be a problem with the MFT and an LPCC. And also now, we need to be very careful. We also license LEP. And I don't know particular this context, which section it belongs to, because
This is MFT.
this is MFT.
Yeah.
Yeah. So maybe for MFT it's okay because it is mental health services. But I think for when we come to the part of the social worker, I would say that, it's probably better to just leave it as service instead of inserting the mental health.
This refers only to MFT.
Only MFT, yeah.
It's not really an issue then.
I had a quick suggestion. Christina, when you first started talking about it, you mentioned there were related services. So what if we said mental health and related services? That's just one thought.
Great. Sounds good.
So we want to change it to mental health and related.
And related services.
I think that's good.
That's
I
good.
think that kind of encompasses anything that's kind of maybe a little bit tangent, but still related.
Question, is that just in this section or in all the sections to make it uniformed, or you're just saying that you want to do that for the social work section?
It's across several, it's in several places in the bill. So there's certain places where it's replacing the term professional services. I can give you an example of that. It's on page 23, line 36. I don't think that there's a lot of difference there, but it will be when the board does review the final draft. It will be something that when you review the bill, you want to pay attention to. If something sticks out as, well, it doesn't quite work in this, we're going to try to make sure that doesn't happen. But if for you, if you have a concern, please say something, and so that we can address it.
Okay. Leah?
One of the charges of the Supervision Committee was to try to make consistent everything that we possibly could. So I would be in favor of making it across the board with the and related service, mental health and related services. And the second piece is MFTs and LPCCs also sometimes do crisis intervention or casework, advocacy type behaviors. So I think it would fit it is more social work than the other professions, but certainly I think it's safer to put that in there. I like that.
Hi, Sarah. Maybe you can just stay there.
I think that sounds great.
Yeah, bring your coffee and just, camp out here. Yeah, go ahead.
Oh, no, I think that's a great solution, so.
Oh, okay, yeah, stay here. Yeah, all right. I like the solution also. Okay, let's move on. Next one.
Okay, moving on, also on page 17, line 39. So we're trying to get away from saying, when we're talking in the law, a lot of times we say, as specified in this chapter and by regulation. The concern with that is that really, when you're looking at the law as a whole, technically, you don't need to say as specified in this chapter and regulation. It's already implied. Sometimes we do it because I think we feel that it kind of helps guide people to, oh yeah, there's regulations that you need to be looking at, but that's not really something that should be done. It's really supposed to kind of stand alone and be assumed. So there's been some places where we've left that in here. There's been some places where we've kind of tried to take it away. A stakeholder raised a concern about this particular one because we're striking it out as specified in this chapter and regulations. The concern that was brought to me is that in the real world, not what we do, there's two types of supervisors. There's maybe your job supervisor, and then there's your supervisor to gain hours. And if somebody were to misread that and not be under a correct supervisor and just under a job supervisor, the stakes are pretty high for them if they just assume that and then turn in their hours to us without asking the question, and then they've got hundreds or thousands of hours that we're going to reject. So I just wanted to bring that up. In that particular case, that was a concern. Technically, if somebody reads that and assumes that it's a regular supervisor, they would be wrong because they're supposed to read the law as a whole.
Right, I was just going to chime in on that. Supervisor is defined earlier in this section, so that there is an official definition if you turn back up to page.
So maybe we could say
Well, in the definition of supervisor as used in this chapter means an individual who meets all the following requirements. That's on page 5 of the bill, so there's already that definition.
So maybe we could reference that definition.
Go ahead.
I was just going to say, if it's already in the beginning of the section, one would have read that part, well, we would assume one would have read that part before getting to this section, so I should think it's implied.
Well, and it's part of the, when they fill out the responsibility statement and such, that it's all kind of further defined in those forms, so yeah.
Okay.
I think we're good.
We're good. All right. Moving along to page 20, lines 37 and 38. This section is talking about a trainee associate applicant for licensure shall only perform mental health services as an employee or volunteer and not as an independent contractor. I'm trying to figure out it's really subtle. I think that we want to somehow say here that that a trainee I think we want to say that they cannot somehow say that they cannot perform any services as an independent contractor. We don't want to say, limited to mental health. Yeah.
I think what Roseanne is getting at is you should not allow a trainee associate to perform any services as an independent contractor, as opposed to specifying mental health.
Leah?
For some agencies, I'm thinking of a wellness center in particular, someone is a yoga instructor there at that agency or that location and can work as an independent contractor as someone who's got all their credentials as a yoga instructor. Of course, they wouldn't be seeing the client that they're doing yoga for, but I think that gets kind of risky because they can be an independent contractor as long as it's not related to the profession of therapy. A lot of I've got coaches going through my program and personal stylists.
Okay. So, then I think that if that's the case.
I think we were trying to get to the issue of that 1099 issue that we have. I think that's what we were trying to get to with this section.
Yes.
There's a huge difference because I know some agencies, that is the only mechanism that they have to award the stipend or reimburse for some, travel expenses and such. So those numbers are significantly different than someone who's actually a 1099, contractor. The stipend and the reimbursement travel, I mean, you're looking at a couple of $1,000s maybe. But conversely, you could get a 1099 for $30,000. That's a big difference. And they want to claim the hours under that.
No,
so that's what we're trying to get to.
Right. I am not a wordsmither.
Yeah.
So with the brilliant wordsmithing abilities of people like you all, I just don't want it to feel like from that particular agency, they can't receive a 1099. They can't receive a 1099 for mental health services related to their pursuit of licensure.
I think the language written here
Is
it's mental health volunteer and not an independent contractor. So means that, it will be, qualified for mental health and independent contractor. That's how I read it, how I read it, so.
I would argue that if you read the statute in its entirety, it's really relating to all of the practices that would relate towards licensure. So if you are a yoga instructor, something that's so clearly outside the context of the statute that it really wouldn't.
Okay, so are you wanting to take out mental health and just put services?
No,
Oh.
I would actually add that it be mental health and related services to stay
Right.
consistent with the
Yes, to
previous
keep it
amendment.
consistent.
And that anything that would be clearly outside of that just wouldn't be part of the statute.
Right, yeah, I agree with that, thanks.
Yeah, if Burger King wants to give you a 1099, I'm good.
Yep. Okay, Roseanne, so we're clear, right?
Yes,
So
we
we're
are
gonna keep
clear.
this
We're going to
one?
add,
Okay.
it's fine as it is, but we're going to add mental health and related.
Yes.
like the previous discussion. Okay. Page 21, line 11. I think here, we're talking about trainees not being credited with supervised experience in a setting that is not a private practice. And I think that the intent of the law is that trainees not perform any kind of service in any private practice. In fact, it's prohibited. So I think we need to add that there, but that's all. I think that's just kind of a cleanup thing.
More structural than anything else.
Yeah, okay. So I'll move on from that one. Page 24, lines 20 to 24. I wanted to have a conversation about this because I know that we require people to perform mental health services when they're under supervision where the employer regularly conducts business. We don't think it's necessary anymore to say that it may include performing services at other locations because that's sort of implied as the regularly conducts business part. If somebody's regularly traveling to some person's house on Thursdays, that's kind of regular business. But I wanted to make sure that there are no disagreements there, because I know especially social workers have a tendency to travel around a little bit more. And this is in there too, so I just wanted to get thoughts on that.
So that will read, conduct business and services. That's fine. Any other public comments? Okay. Yeah, it's clear. Sometimes, I think, the more words is good, but at the same time, again, this is just make it a little bit broader, to allow some flexibility. And it's mental health and related services anyway. So.
Right. I know we had a discussion about that in the past, so I just wanted to make sure there were no strong feelings about it. Okay. All right. Page 25.
Oh, Jonathan.
Jonathan Maddox, LFT in California. I have a question. So could you further explain what that means, that a trainee or associate could only provide services where someone regularly does business? Because I was just told that the example of someone who regularly meets a client, like in Starbucks, because that's where the client feels safe, or that's the only place the client has access to or time to meet. Would that be included? So maybe we could expand on sort of what that means, so I can have clarity on that, or understand better.
That would be included. I think what we're trying to get at with the way that the law is written is we don't want the supervisor to allow the trainee or the intern to set up a independent practice where they maybe check in once a year, once a month, they're never there. The intent is sort of to disallow that. But if it's part of their job, they are meeting somebody at Starbucks because that's where they feel comfortable, that would be part of the practice.
Okay, so there is tremendous flexibility for agencies that provide services to clients that cannot come to traditional settings to meet regularly wherever that is. Thank you.
I believe that would still be covered, yes.
I just want to, I feel like, it could be interpreted where the employer regularly conducts business. Do you regularly conduct business at a Starbucks? I just want to throw that little wrench in there. Well, that's the way this is reading, where they regularly conduct business. I
think my concern is I actually work in a public mental health system, and so one of the things that we prioritize is engaging clients where they are. And many times, due to numerous racial and historical traumas from certain populations, they are uncomfortable coming to actual government buildings or agency buildings to receive care. So one of the things we do is to minimize and eliminate barriers to care. We meet clients where they are, so wherever that may be. So that may be in a Starbucks. I mean, it's not the ideal situation to provide clinical care, but that's the reality of what happens in the work. And so I think we need to make room for practitioners who are trying to lower health disparities by meeting clients where they are and creating opportunities for them to feel safe to meet in their communities or in locales that are important to them. So I think any language that would impact that should probably be minimized, because ultimately we're here to protect. Good morning. We're ultimately here to protect consumers, and if consumers can't access care because we won't meet them somewhere, then I think that's a challenge.
Okay.
Leah? Yeah, go ahead, Leah.
So my assumption is that if somebody makes a complaint, the BBS would investigate it, and it was the BBS's job to interpret what regularly conducts business means.
Right, and I think if I got a response from the subject of the complaint, and they explained in terms that Jonathan just laid out, that this was a way to meet the client and, basically destigmatize the whole idea of getting mental health services, and then provided me some information as to how they kept that confidential and it was private, I would find that not to be a violation.
But if somebody just randomly, without good justification and talking to their supervisor, decide to meet their client. We had one who took a client to a baseball game.
Not good.
He's not in our program anymore. That would be a case where...
That's a different scenario.
Not a good idea.
That's a different scenario, because I think the concerns that Jonathan cited are very real.
Yes.
And if you've got that client that's willing to make that first step, I think it's in the best interest of the client to meet that client halfway.
Under supervision.
Under
Supervisor
supervision,
knowledge
right.
and documented.
Right, because maybe there's an opportunity, okay, so you move it from a Starbucks, maybe we start transitioning to another environment that we would view as more traditional. But I think the point is the individual is now open to the idea of getting the services. So let's see how we can bring them in.
Further, Kim and Roseanne's point, this is putting the onus on the employer and the supervisor, so it's to protect against rogue interns, basically.
Right.
I think striking out the language is actually create a little bit more space and flexibility. So I actually like that. And it's really talking about supervision. So, yeah. Thanks, Jonathan. Thank you, Sarah. And thanks, Leah. All right, Roseanne. Next.
Next is page 24, lines 28 to 31. And this is where we get into an issue that has to do with corporations and private practices that we're kind of starting to touch base on in our exempt setting committee, but it needs some work. And then that is the issue is that we need a better definition of corporation and private practice in our law, because a corporation actually is a private practice, and a private practice could be a corporation. And so we kind of throw those terms around, and we really need to sort of better define what those are. And I think we're working on that in our exempt setting committee, because we refer in our law to corporations, and we refer sometimes to private practices and exempt settings, but then we also have some entities that don't really fit into those categories very well at all. So it's sort of a work in progress. But in this particular case, we're talking about the fact that an associate who's employed or volunteering in a corporation or private practice needs to be supervised by an individual who's either employed by or practices at the same site as the associate's employer, or is an owner or shareholder of the private practice, or is employed full-time by the Marriage and Family Therapy Corporation and is actively engaged in performing professional services. So previously, we had those more split up into, if you're a private practice, you need to do number one. If you're a corporation, you need to do number two. I think that this particular section works as it's written, but I wanted to draw attention to it because it's kind of a part of a bigger issue and a restructuring that we're doing. And so it might be worth some discussion.
So the current language, does it change the practice that we currently have?
The current?
So the language being inserted, does it change, the existing law?
I don't believe so, because number two, the way that it's written would just apply to a corporation. But we are sort of blending the two together, whereas before we kept them separately. And over time, we're going to, in our exempt setting committee, we're going to come out with a definition of an exempt setting, maybe a non-exempt setting. Private practice will need to be defined better. So we're starting sort of that process here. And so I think it leaves the same intent. I let Sabina.
The intention here was just to structurally reorganize it, but to add to Roseanne's comments, the corporate form is really just a personal protection of assets. So one person in a private practice can incorporate. So one person can be a private practice and a corporation. A corporation can be a private practice or it can be a not private practice. So the distinctions are not as clear as I think was imagined in drafting of all of these sections. So I encourage you, it's something to resolve in AB 90.
So we are in a good direction.
Yeah, and frankly, I don't have any particular preference about how, or there's no policy concerns on my side. I just, if you could imagine what you were originally going for and just tighten that up a little bit, so.
And does this language as it is do that? Tighten it up?
I think this section is fine the way it
Okay.
reads, but when there are differences about a corporation can supervise 10 employees and a private practice can only supervise one, somebody can pick which one of those things to do, probably not in the manner that you were intending, so.
So I think that if we leave the language the way it's proposed, that gets us there in terms of this bill, and then we continue the work in the exempt committee to really refine those definitions.
Definitions of the corporation and private
Right.
practice.
Because
Yeah.
if, if we're good with that, then, and the bill is successful, then we get the changes to the supervision in that we want
Right.
and that we need, and that'll benefit the population, but then we can come back around and further tweak that definition.
I'd recommend that you deal with the supervision corporation private practice in this bill.
I can kind of lead the discussion that the next two items that I was going to talk about, it's kind of all leads into the corporation, so we can kind of look at a couple of those issues too. On page 25, lines 25 through 28, we're striking out a subsection that says employment and supervision within a marriage and family therapy corporation shall be subject to all laws and regulations governing experience and supervision gained in a private practice setting. That's because it really, one can be the other. So that's where Sarah's talking about it. The water's kind of muddied between those two because somebody can sort of pick and choose and they blend together. Also on page 25, lines 28 and 29, we're saying, in no event shall, and maybe this is where we need to look at a change, in no event shall a private practice retain at any one time more than 3 supervisees. So that's a little bit of a departure from where right now it's somebody in private practice can have 3 each. So this is changing it to a private practice 3, but then a marriage and family therapy corporation can have up to 15. I think the original intent of the law, the way that it's written right now, is that if you're a private practice, you can have 3 each in your private practice, but if you're a corporation, you're limited to 15. And that's sort of to eliminate like intern or trainee mills where a corporation is just employing all of these interns and trainees that are working under a couple of people. But if a private practice can be a corporation, then they would technically be limited to 15.
Right.
I don't know that we want to limit them to 3 either. So if it's a private practice, so that's kind of where we need to, I think, make a tweak.
And these sections are not, there's no recommendations in here, so any strikeouts that you see are just purely structural in this version of the bill, so the policy discussion is open to you.
For us. Alon?
Thank you. I just wanted to, I guess, piggyback onto what Sarah was saying, is just to make it more clear so there's not confusion about how many supervisees there can be under one supervisor in a MFT corporation that can have a maximum of supervisees. So just to make it clear.
I could also jump in one more time. You might even decide to get rid of the distinction between private and corporation altogether. If you're really just concerned about a supervisory experience, it could just be limited to supervisors in any form. That's something for you to discuss.
Jonathan?
I think to piggyback on that, I think one thought I was thinking was that maybe we just specify a particular ratio for licensed staff who are licensed practicing practitioners, that there be a ratio of how many supervisees they could hold under them that kind of crosses both into the corporation. Because there is a concern about quality of care, about the skill development of supervisees, and once again, there are places that just create these mills where they bring in all these trainees. Trainees do all the work, they, all the pay, and not fair to the trainees' experience. So,
Leah?
So, yeah, I was thinking also of separating out this idea of private practice versus corporation, because I'm thinking, so a corporation could be just one person. So now they have 15 people. Yeah. So I think the ratio is probably a better way to establish it. A private practice or corporation can have no more than 3 supervisors. supervisees per supervisor.
Advisor. Yep, doable. Okay.
If we would, currently the law says that it can be three supervisees per person for a in a private practice or a corporation. The way that it currently works right now is if it's a private practice, there's no limit. I mean, if you have 10 people in a private practice, they can each have 3. Do we want to limit that, or do we want to say that if the private practice is incorporated, it's only 15? I think there needs to be some clarity of where that distinction ends.
No, but I was going to say, doesn't Jonathan's point to the ratio in terms of supervisors to the supervisees address that issue?
I think it would. You could have 4 supervisors in an agency setting, and if they're only responsible for 3 supervisees, you know, there's that control and that oversight present. And I think it eliminates the idea of having a single supervisor. I'm in a corporation, but I can have 15 people. So I almost like I like the ratio where you just specify what a supervisor cannot have responsibility for any more than X supervisees. And and you can apply that across all the settings.
That becomes problematic because, you know, I do group supervision, so I'm responsible for 8, the maximum.
But group supervision is different.
It's different, but, you know, I think that would probably, I think that would warrant some, you know, further discussion, you know, if it's applied across board. You know, I think right now, this is on private practice, and I think it's important that we stay on the private practice route first, and then we deal with the distinction, you know, between the individual supervisor and then the corporation. Because I think, you know, the tricky point is we don't have a very clear definition what corporation is. So, you know, if we leave the language as it is and yet, you know, add the ratio so that, you know, that unless, you know, the corporation have 10, you know, supervisors, and then they can supervise 30, you know, that would become, you know, that.
I don't know that that's a problem, though, because they're still getting the same quality. Every person, every supervisor has no more than 3 people. So, first of all, I don't think there's a private practice that's going to have 10 supervisors. That's way too expensive. But if that were to happen, you still, with that ratio, you're still protecting the public with no more than 3. So rather than putting a maximum, if you have 10 people, that's almost better because it runs then like a regular community agency where you have lots of supervisors around. So I like the ratio in private practice and corporation. I don't know the conversation about other agencies and maximums. That's a separate conversation entirely and a different structure.
And I think, too, the other caveat to my experience is that whenever agencies are large enough where they have both group and individual supervision, there is an identified individual supervisor who signs off on the hours. The group it may be the group or the individual supervisor, but the other supervisor acquiesces to the actual clinical direction that's provided by the supervisor that's signing the forms. So I don't see it as a contradiction in that point.
Can I make an announcement? When we're speaking into the mic, I guess we're getting a low volume over here, so as loud as you can.
Sounded like I was talking loud, I'm sorry. Should
No,
I say that again?
You were pretty good. Is that good, though? No. I think it's fine. Just for now on.
So
We are webcasted, so it's important that you know, that being captured in the microphone and, yeah.
can I toss something out there? What if we got rid of the 15 supervisees limit in corporation and just said something like a supervisor in a private practice or a corporation shall not supervise more than 3 supervisees?
Yes.
That work for social work?
At any one
That
time.
good? Okay, good.
Can I just ask a clarifying question? And I'm assuming supervisee is already defined as a trainee or associate? Okay.
So, yeah. Okay, thank you. Yay. Okay, next one? Yep.
really minor things, they're almost cleanup. So page 72, lines 20 to 21. This is part of a bigger conversation we're going to be having in about possible legislation for next year, but I just want to point it out here. We're striking if the applicant meets the educational requirements for in effect at the time of the application for a subsequent associate registration number. So striking that is, I think that I had a conversation with legal, it's fine, because basically, if you're getting a new number, you have to meet the current requirements anyways, the law implies that. But we are having a sort of a side conversation in our licensing unit because some of our requirements have changed over the years. We went through a really long period of time where we didn't have any major educational requirements, or they could be made up after the fact, but we've switched from 48 unit degrees to 60 unit degrees over time. We've eliminated the ability to remediate certain things like assessment and diagnosis for LPCCs. So that is raising some questions in the licensing unit of is that really the best way to have that language worded there. So we're going to be looking at that a little bit later today. I don't know if that goes in a separate bill or it becomes part of this bill. But we're going to look at a couple of different scenarios for that language. So just wanted to point out that it's in here too. And then page 72, lines 15 through 18. We just need to make a minor change to that. Technically, a registration can be renewed 5 times, not 5 years, so it's a total of 6 years. So I'm going to be changing the language a little bit on that one. And the same thing with page 84, lines 6 to 21. We're trying to get some sections in there that are kind of written a little awkwardly cleaned up, so there's going to be some different language for that. But I don't think it's anything we need to discuss right now. So I guess with that, those are the main things I wanted to bring up, and let Camp go for any other items.
I don't have anything to add. I just wanted to, was there language pinned down with respect to removing California, the word California from that section of the statute, or was that something that you were going to?
It's not pinned down. I need to go back and look and see if we can find a reference where it talks about a supervisor can be a licensee of Board of Behavioral Sciences, Board of Psychology, or a certified psychiatrist from the medical board. I need to find that language and pin it to that, basically.
Cool, thanks.
Any other, so this is it, right? Oh, Christy.
I hope I'm not being a sticky wheel here, but can we go back to page 24? I just want to point out one little thing that maybe we didn't notice, and maybe this is nothing, back to providing services at the place where his or her employer regularly conducts business. What do you think of saying at the places? To me, that's singular, at the place. So I just wanted to point that out.
So you want to add an S?
The places.
Places,
I would feel
to
more
plural,
comfortable with
yeah.
that.
Okay.
Any other public comments or board members' comments?
I just want to tip my hat to Roseanne for her hard work and collaboration with Senate BMP to make this work. The work represents a lot of stakeholder input and desire to definitely improve the direction and quality of supervision. And, when we collaborate, we tend to come out with something better. So thank you very much.
And I just like to point out the timeline for this. So our November meeting is the week after next. You're not going to see this here. What will do is I'll work with Sarah. We'll go back and have Ledge Council draft something based on all of everything we've discussed here today. And then you will see it we'll likely bring it to we have a policy and advocacy committee meeting in February, so it'll be at that meeting. And then you'll see it at the March, assuming everything's good, you'll see it at the March board meeting for the final approval. And then the bill needs to move by next June or July. The calendar's not out yet, but in order to stay alive.
Right, and the meeting, the board meeting would be the last week in February. We had to move that one. Sorry.
So do we need any action in regarding this bill, or, Roseanne, you're going to just take the recommendations and rework some of the wordings and the languages and
we'll rework it, and I
bring it
definitely
back.
want to thank Sarah for showing up today and for working with us on this, and also our stakeholders who came out and are listening for their input.
Thank you very much, Sarah. Yes. Okay. Yes, let's take another really quick break. So the time now is 10:37. Let's come back at 10:45. Thank you. Let's okay. We are good. So let's restart the meeting. And the time now is 10:51, and let's continue our Policy and Advocacy Committee meeting. And the next agenda item is the proposed 2018 omnibus legislation. And Roseanne, you're on.
All right. So, we do the omnibus bill every year. It's for minor technical cleanup items. So we just have a few things to talk about in terms of that, and I'll go through them one by one, and I guess I'll take questions after each one, and then anybody can weigh in at the end. The first item we have up for consideration is amending Business and Professions Code Section 27, disclosure of information on licensees and registrants. In really short, this section requires the boards and bureaus under DCA to disclose certain specified information. For most of the boards and bureaus, if they have licensee and registrants, it straight out says licensees and registrants. Our board doesn't do this for whatever reason. So we would like it, instead of just saying it's licensees, we would like to say licensees and registrants. So.
Any board member comments? I see thumb up. Any public comment? Nope. Good to go.
Second item is also pretty simple. We are effective coming January 1, 2018, changing the intern title to associate. Last year, we changed that in the law in anything that was being run already as legislation. So this is just kind of a sweeping cleanup. Anything left in our particular statutes that was not changed, we're touching that this year. Like I said, pretty straightforward change there.
Oh, it's a fall cleaning bill. Yep, okay. Alan, you have a question? Yep.
I was just wondering what, Camp is interested in knowing what we should tell our members about the change if the law is not passed by January 1st, 2018, like.
So the law is actually already passed.
I mean, or it's the regulations.
The regulations
are changing. I'm sorry. Yeah.
The regulations are the advertising guidelines, and so, do you know what the status is? I think that one's at.
It's going through the final review process through DCA and agency, so I do expect that it will be take effect by January 1st.
Okay.
There's never any guarantees with that process, but I am anticipating that to be the case.
Cool. Thanks.
Okay.
Any other questions? Good. Next.
Okay, so the next item, item number 3, is a big one. It's actually a pretty crucial issue. We have sections in our Business and Professions Code. It's 4980.37, .39, and .41, and then 4999.32 for LPCCs. And these sections are basically the old education requirements that are phasing out. It's for people that began graduate study before August 1, 2012, and complete that study by December 31st, 2018. So those sections are for people that started their education and completed it within a certain period of time. The problem is that we noticed that those sections have expiration dates of January 1, 2019. They're set to repeal. That shouldn't happen. The sections, I think that the intent was those sections are for people that had an older degree that gained it in a certain amount of time. I don't think that it was ever the intent to allow those to go away completely so that I didn't, if they went away, then everybody with an older degree would have to meet new requirements. So I don't think that it's the intent for that to happen. So we just are proposing to repeal those sunset dates. I did a little bit of looking at the committee notes from when this legislation was ran in 2009. There were some committee meetings in 2008 where they were talking about the older degrees and sunsetting the actual, when did the person have to be finished with the degree by, but there was no discussion of ever in the future making it go away. Eventually, they'll become less common, but staff recommends striking the 2019 sunset date.
So Leah agree with it, Yep. Yep, this is good. This is really good because it really adds a lot more clarity, to the education requirement. So it's not confusing. Yep. Okay. Any other board member comments or public comments? Good. Okay. Let's move on.
Okay. Item 4, it's talking about accepting the clinical exam score for an out-of-state applicant. And these sections allow an out-of-state applicant who obtained a license or registration in another jurisdiction to apply for a licensure with the board without taking the clinical exam again if they are active in good standing and they had passed that exam, the equivalent of that exam. The law currently allows the applicant to apply for licensure if they meet the requirements, being in good standing and having passed the exam. It would be more, instead of saying they can apply for licensure, it would be more accurate to state that they may qualify for licensure. So we just want to change that word.
It's good. Yeah, it's way clearer because application and qualification is two different things. Yep. Great. Thank you, Roseanne. The next one.
Next, item 5, there is a reference in the out-of-state requirements. It's a reference to practicum. For in-state applicants, practicum is referred to as supervised practicum. For out-of-state applicants, the law simply mentions practicum. We want to refer to practicum for out-of-state applicants using the same terminology as is used for in-state applicants. So we just are making a few minor cleanup changes there for consistency.
With the word supervised.
Yeah, it's slightly different for LPCCs and LMFTs. We just want to make it the equivalent to what's mentioned for in-state.
Leah?
But it's just how we're referring to it, right? Because in other states, they refer to it as internship. They don't, practicum is their before internship experience where they see on-campus people, and then internship is what they see at their agencies, and then they graduate, so it won't matter.
It's not changing the meaning, it's just making it consistent in our law how we refer to it, yeah.
All right, I don't see any desire to comment, so next one.
Okay, and then item number 6, this is just a minor technical change to a date reference that's obsolete. It's from the 1980s. It just needs to come out. And then we're just making a minor reference to an exam because of the timing of when our exams have been taken. So it could be one exam or the other, not necessarily both. So just tweaking a couple of words to make that more clear.
And up to date.
Yes.
Any other comments? All right. And then there's the last one.
The last one, and hopefully everybody got the additional attachment B, and I think that was put up there for the audience as well. The Psychology Board is actually going to propose a omnibus item this year, and it also affects because both us and the medical board also license different forms of mental health providers. It applies to us as well, so they wanted to share the language and ask for our input. It's about the requirement that the board and therapists, it has to do with the professional therapy never includes sex brochure that's required in certain circumstances where a therapist finds out that there may have been that type of contact with a previous therapist and a patient. And so they're just proposing some minor changes to bring the language a little more up to date, and you can see that here. I just wanted to see if there was any feedback or comments.
And just to further add to that, I've been working with the Med Board and the Psych Board to revise the language. They have some proposed language out, and then we're going to be sharing that for the new brochure with some of the subject matter experts who are licensees to get their feedback on it. But a lot of the language in the brochure was outdated, so we wanted to clean that up a little bit and just move forward. And then we started taking a look at this at one of those meetings and realized that the code section is actually outdated as well. So I have no concerns about what's being proposed.
Any other comments? Okay, so we are ready for a motion. Christine?
Move to recommend to the board to accept the proposed changes or the omnibus bill.
package.
Yeah.
I'll second that.
Package. Yeah.
You want a second or I second?
Could I please second?
Okay, Samara second. So Christine first and Samara second. Any other discussion? Okay, we're ready for vote call.
Wong?
Yes.
Brown?
Yes.
Dr. Christine Whitliswalk?
Yes.
Samara Ashley?
Yes.
Motion carries.
Thank you very much. Okay, so the next agenda item is the discussion of education requirements to obtain a subsequent registration number. Roseanne, please.
Okay, so this agenda item is something that I alluded to in the discussion of AB 93. So this is a little bit weird because we have an active bill that's going through. This is a little bit of a different topic. This is kind of new ground for me. And then also the following agenda item is a slightly different agenda item, but it affects those same sections. So not sure how this is really going to come out in the wash, but not really sure this is even ready to move forward as anything, but we're going to have the discussion and just know that there's kind of a lot of moving parts to this. But one issue that our licensing unit has brought to our attention has to do with the education requirements to obtain a subsequent registration number. And we talked a little bit about this at the last meeting in August or September, and we've kind of done some more retooling and brought it back. But current licensing law requires our associates to renew their registration number each year for up to 5 times or 6 years. And after that, they have to get a new subsequent registration number. And to obtain that, the law says that they have to have passed the California Law and Ethics exam and also meet the educational requirements for registration that are currently in effect. The educational requirements for a long time, they didn't change much, but over the past few years, we've made a lot of changes to them. The units have increased for LMFTs and LPCCs from 48 units to 60 units. The core content areas have increased for LPCC. The practicum hours have increased for LPCC, and all of that's probably okay to say because current education requirements include both old degrees in 4999.32 and newer degrees in 4999.33. So the issue isn't really come into play too much there as long as we interpret it that way. But we last year changed the law so that LPCCs have to have assessment and diagnosis in their degree, and there is no remediation and no exceptions. So it seems a little bit strange for somebody who's come through maybe remediated assessment and diagnosis post-degree to come through and then all of a sudden not be able to get a second number because they didn't have that. And then a second issue would be a situation where an individual applies for a second registration number maybe many years after their first number expired. They might meet current educational requirements because they have a degree that was gained a long time ago, and they may have passed a law and ethics exam a long time ago. But the question sort of is there any public protection concerns with having this applicant come back in and practice after 5, 10, 15 years with no current education or experience? So we discussed this in the August meeting, and it was suggested that if an applicant had not been registered for a specific number of years, maybe that they should be required to take some kind of coursework to refresh their knowledge about that topic. And staff was directed to examine what that coursework might be. So attachment A shows some draft language that I've written with input of our board's subject matter expert. And then I also took a look at some other licensing boards under DCA that require extra coursework in certain circumstances. Not all of it is required in these exact same circumstances. Some of it is if somebody hasn't been practicing for a long time. Some of it is if they don't pass an exam after a certain number of tries. There's different kind of reasoning for it, but it just gives you kind of some examples of what other boards are doing. There is one additional amendment in this language that's a little bit unrelated to what we're doing here, but in section 4996.28, A, 4, and B, there's an incorrect statement that needs to be corrected. It states that to renew a registration, the registrant must obtain a passing score on the California Law and Ethics exam. That's not the intent of the exam restructure. It should state that to renew a registration, they have to participate in the Law and Ethics exam, and then passage is only needed for a subsequent registration or to obtain a license. So we've corrected that here. That would need, if we don't move forward with the other piece, we need to move forward with that piece today. So I'll open it up for discussion. You can kind of see what we've worked to propose. We kind of looked at the different coursework and thought what might be important to do a refresher on if a degree was very old. And we kind of left the number of hours blank for now.
So I have a technical question. So there is no inactive status for registrants, right?
No.
So if they stop practice, so let's say they have their registrant number for 5 years, and they have decided that, no, it's too much, I cannot get my clinical hours, I stop practice. And then 10 years later, they got hired in a mental health agency. And then, so what do they do at that point? Do they just apply, renew, or?
No, they can't renew the registration because it's hit the 6-year mark. They reapply for a subsequent number.
Right.
So then they get that second number.
Okay.
And then they have to start gaining their hours, and they can't work in a private practice setting. So the concern, I think that maybe it isn't a concern, but, they've been out of the industry for a period of time. And when you consider the changes that have occurred, let's just say in the last 10 years, do they have the skills and knowledge relevant to current practice?
Because currently, a lot of the social workers employed in the child welfare, CPS, they want to, accumulate some clinical hours, and they were able to do so up to a certain point.
Correct.
And then, sometimes, some of them decided to stay in the field, and then, of course, they will have a harder time in collecting those hours. So I'm thinking, and then oftentimes they drop out, and then they re-pick up the license again. So in that case, they may or may not even exceed that 5 years. They might be just licensed for, being the registrant for a couple years, and then they stop. And then so at that point, they also need to reapply.
Right, because what happens with the registration, it goes delinquent. And the registration is only valid for a total of 6 years. So if they come in year 7 and claim, gosh, I only used it for 2 years of my first registration, they still need the second registration number. So, that's kind of it's just the process right now. And I was looking at the language in the one, in subsection C, wondered if it would provide further clarity in the sentence that begins with no further renewal, when no further renewals are possible, a previously registered applicant may apply for and obtain a subsequent number. Because when I first read that, I thought, ooh, anybody could get a subsequent number. But if we're talking about, yeah, so that, and then you could have that, I don't know, I just thought that that phrase, previously held or previously registered applicant, might add a little more clarity and kind of get to where we need to be. But that was just my thought. I don't know how anybody else feels about that.
The other thought that I have is, this is just for people that had a registration at one time and are seeking a new one. I talked to our licensing unit. It doesn't happen very often, but somebody could, in theory, graduate, never get a registration number and come back. That's kind of a different animal. And where do we put that in the law, or what do we do about that? But I don't know, the issue kind of started with the subsequent registration number, so.
And then go from there.
Yeah.
Yeah, it's a good starting point. Yep. Okay. And then one of my other, just a little comment, on the attachment A, the list of the classes, the number of hours in assessment, diagnosis, and prognosis. I wonder, the word prognosis may be better replaced as treatment planning. Because we don't do prognosis.
No.
We don't decide, how well you're going to recover down the road. So it's really about that clinical triangle of assessment, diagnosis, and treatment planning. And then the next phase is, intervention.
Okay, I think we would need to, we can definitely change that. That's going to be needed to be changed in other places too, because that language is taken out of the 4980.32 and 33. That's the way it's referenced in law right now. So we can go through, I can go through and find those sections too.
Okay. Dean first.
May I just ask a brief question when you're talking about the 6-year window? Is there any way an intern can take an official break for health reasons? I've had the question just this week. Intern is having a difficult pregnancy, needs to stop doing her intern work. She wondered if she should let the BBS know that, she wasn't going to be collecting hours, or is it simply she may even have to get a new number if she can't get it all done in that 6-year window, taking 2 years off.
Right, and that's what would happen, is she doesn't need to let us know. She just stops collecting the hours, and then when she's able to go back and gain more hours, and then when she gets enough, she can submit all of the hours. We will only look going back 6 years.
6 years.
Mm-hmm. There's no mechanism in the law to allow for a medical condition or any unforeseen circumstance, because I've had the argument with, not the argument, but we've had the discussion, and we understand life intervenes, and that's why they are allowed having that subsequent registration so that they can continue. There are other states out there that cap how long you can be registered, period. So they have a way to get back in. I think the angst they suffer is that I might lose those earlier hours, and I empathize with that, but the point of having the 6-year reflection back on the hours is to make sure that that individual has the knowledge relevant to current practice. So.
And Steve?
I've always had a trouble with the subsequent registration, actually terminology. It should just be a registration in my thoughts. I don't know where I'm going to go with that thought. But the 6-year, the education, I like what I like the idea because of the situation we have now that you have, you can remediate these things. As we see, our laws are very complicated, and this just adds another complication to it. I'm not sure necessarily proposing, but First of all, that 6-year, the education really comes on the application process when they want to get to the clinical exam. That's going, like we were just discussing. That's going to say at that point, we're going to have to look at the education and make sure it's okay, no matter when you came into the game. I'm not sure why we have the subsequent registration and designation. I think it should just be registration. And then where we take it from there within our laws, maybe we have to redo the laws and say that, you have a registration for 6 years. After that 6 year, if you have a registration for more than 6 years, not call it subsequent, that you actually have to, with some of the other rules we have, like you can't practice in, look at it not as a subsequent registration, but registration as a whole and a time and length, and look at it that way. Because right now, really, that subsequent registration is, in effect, it's just like a renewal application for most people. And it kind of confuses everyone, I think, and causes complications. So I would propose possibly, getting rid of the subsequent registration designation and looking towards just as as a registration number.
And maybe this is part of a bigger discussion, I think, in
February,
where we have it slated to, we had about a half a year ago, a discussion about the 6-year rule, and that was supposed to come back in the first Policy and Advocacy Committee meeting of 2018. So we're going to be having that discussion again with a little bit more research being done. And maybe this is part of a bigger picture.
Right. And it seems to me that, with Steve, I think we talked about that possibility in one of our P&A meetings. And so it becoming like two competing bills, it's like, yeah, we allow, but at the same time, whether we should be even allowing to have another subsequent number.
And I could bring this as a piece of that. It might be part of an answer, but it may not be the whole answer or where we ultimately want to go.
Right.
So.
Yeah. Leah? Sorry.
I have a couple things. One question is, you had talked about if they didn't have the assessment and diagnosis as part of their degree for the LPCC, right? So are you changing it where they'll be able to remediate that? Is that, because I'm looking at this and I'm like, wait, I thought I heard you say that, and that isn't part of this discussion. So I just wanted to get clarity.
No, the language in here says meet current education requirements to get a subsequent number. So we were talking about striking that and putting in this extra, so they wouldn't be able to remediate it, but they would just go on as if nothing had, there's nothing that says they have to meet current education requirements because they already met them the first time, if that makes sense.
Yes, okay. The second just complication I'll throw into this, your online CEUs, no big deal. You just print a certificate, type in your name, print it out once you finish the test. But some of the conferences that you go to, especially the larger ones like the Evolution of Psychotherapy, they look for your license number to give CEUs. And the culture is, the assumption is you don't need CEUs until you've been licensed. So there's, I don't know, that just really complicates things. It may end up being no big deal and they'll just print out a certificate without a license number, but I can't say for certain that won't be an issue, because they may go, well, no, I'm just trying to get a registration number because I've been out of practice for a while. I don't know if they have to have that in their field in their computer.
So I'm wondering, so is it a problem?
I don't know. That's what I would encourage us to investigate that. Maybe looking at some of the Evolution of Psychotherapy conference is coming up here or it's going to be in Anaheim in December. Probably if they could do it, and then looking at maybe ACA and AMFT and the Social Work National Organization, and just check with them to make sure it's not an issue to get CEUs without a license number. And if then it is, then that's a non-issue. But I just want to check that, having gone to conferences where they need a license number and they say, oh, well, you don't need it. And then what happens is the potential registrant gets really confused and says, well, I didn't need it. I went to the conference, but I don't have a certificate. So
Right,
I
so
just,
then yeah.
because it's a cultural thing that
Understood.
makes it difficult. So that's one piece. The second thing on your, I like this idea of, I think 5 years is good, or maybe 7, because definitely 7 years, there are massive changes. I know many of the national organizations change their ethics every 7 years, but 5 would be fine. I don't know where you came up with 5. And in terms of the actual continuing education requirements, the number, Roman numeral 1 and 2 on cultural competency and cultural sensitivity compared with multicultural development and cross-cultural interaction, I'm not familiar that those are separate courses. They're the same course, so that feels kind of redundant to me, I would say, in working with diverse cultures. And just keep it broad and do one Roman numeral for that. Yeah, and the California law and ethics, that's the other piece that really, really changes. But in terms of content, I like the culture, law and ethics, and the assessment diagnosis. The only other class I could imagine that would change a lot is where you require psychopharm. Psychopharmacology changes remarkably. I don't know that anybody has anything less than a 2-unit class right now, because that's what we require. So that might be another area that changes remarkably from over this period of time.
We might want to look at the courses we require from out-of-state candidates in recovery-oriented care and California cultures, because those were probably already out there.
Okay. Pam?
I'm sorry, go ahead.
No, go ahead.
Well,
You
I'm kind
finish.
of wondering, since we're having a lot of discussion around this component of it, and Roseanne initially talked about we couldn't decide them pulling this part back, but moving forward to make the law clear about participating in the law and ethics. Want to throw that out there as a suggestion. Maybe after we hear all the public comment, perhaps we take this piece back.
Actually, so the next agenda item touches that section, so I've already built the change in there too.
Go ahead.
So we would need to.
Yeah, right.
And this is
Next,
why
yeah.
staff makes me look so
It's
good.
weird because we don't usually have this many moving parts.
Yeah.
But
Yes.
we're okay not approving that piece here.
Okay.
Okay. Pam?
Hello, my name's Pamela Smith, current MSW intern. And I'd just like to agree with what you're saying about the number for getting CEUs. I currently use a drug and alcohol number credited towards me for different trainings, but without that, some of my fellow students over here, they don't have that option to get the ethics and law certification or the CEs and some of the others that we have to have in certain situations.
Thank you very much. Okay. So, any other comments from board members and public? Okay.
I just want to
Just
clarify.
a real
Okay.
quick, the passage of the California Law and Ethics exam, what if they already had passed it in the last, and they're coming back to get a subsequent? I guess that doesn't matter, never mind.
They would already have passed it, but that kind of raises another issue is that we haven't seen yet, but we may see them on the road, is there's no limit on the age of the law and ethics exam.
Leah?
So, in a way, it feels redundant that we're requiring a course in law and ethics and making them take the exam. If we're taking the exam, they're going to have to do whatever it takes to pass that, which might take care of the CEU piece for that particular issue. And then the other part, I want to clarify what you guys are thinking of doing. So you'll keep which part and not add what part?
There's a section in section 4996.28 that needs to be fixed. That's and it's wrong, but the next agenda item addresses that too. So we don't need to worry about it right now, because if the next agenda item is approved, it'll get
Fix
taken
that
care of.
issue,
If it's
yeah.
not, then we need to talk more.
Right, right.
So we're thinking for these items about the language in each of these 3 sections dealing with this more?
Yes. bringing it back and
Yeah.
at the next P&A meeting? Okay.
Yeah. Dean?
In the background information for this issue, we've talked about the fact we added that assessment and diagnosis must be within the degree to the LPCC statute. We added it to both the older degrees that were 48 units and only 9 core areas, as well as the newer degrees post 2012. I'm getting feedback from universities and from students that they are now blocked from being able to apply to be an intern because the rules, the law in effect when they earned their degree did not require assessment and diagnosis to be within the degree. When we did that last year, and it went into effect this January, we really did it retroactively. And now I'm finding there are people in the pipeline that may be taking diagnosis or assessment post-degree, and they felt they had, coming in under 499.32, that applies to people who began their degree before 2012 and complete it before December 31st, 2018. So they thought they had until 2018 to make up 2 of the core courses.
Oh, okay, and that is a concern, but that's not part of this right now, so.
Actually,
Kind of is?
it kind of is
Could be.
because it does have to do with the person coming back and getting a subsequent number when the language reads that way.
I guess that'll be part of the February
Oh,
discussion?
yeah, I think it's a conversation that I think we need to entertain. I mean, maybe it's a discussion. I mean, the board did decide that assessment and diagnosis was integral, but in terms of how soon, maybe that needs to be revisited.
Well, maybe we could have a phase-in period or something that would allow those in the pipeline to not have it blocked.
I guess we'll add that to the February meeting.
So Roseanne, looks like we have gathered enough feedback and comments from the public, and then we can just bring those comments and incorporate them, and for the next either P&A meeting or board meetings. PNA meetings.
We bring it to P&A, correct?
Yeah.
We don't want to, yeah.
Okay, sounds really good. Thank you very much for all those who come and give us feedback. So we will move on to the next agenda item, renewal of expired registration number.
So, different issue affecting the same code sections. So current law specifies actions that a registrant must take before to renew a registration number before it expires. But the law is silent on the actions that are needed to renew a registration number once it has already expired. So this proposal would specify how an expired registration number is renewed. And the reason this is an issue is that we have a section in our law that allows the board to commence or proceed with an investigation of disciplinary action if a license or registration is expired. But there's some things that are proving to be problematic with that. We have the authority to take that kind of disciplinary action, but we still have to take that case to the Attorney General or to administrative law judges, like if we're doing a PC 23 to revoke a license because of an immediate danger. The Attorney General and others in the legal profession dealing with the board don't always understand that renewing an expired registration is just simply a matter of submitting a renewal form and paying a fee. They think that it's expired, it's expired, it's not gonna, not that easy to renew. That's not the case. So when the Attorney General's office is appearing on the board's behalf in a criminal proceeding to obtain a PC-23 order, the judges aren't understanding why a PC-23 order is necessary to restrict the person's practice because the registration is expired. And due to this occurring several times, the Attorney General's office and DCA Legal have recommended that the board pursue legislation to specify how to renew an expired registration. And so what we're basically proposing is that we just add a sentence in that says an expired registration can be renewed by completing the same actions to renew an active registration. The law still says that no registration shall be renewed or reinstated beyond 6 years. And so it would still hold that they would need a new registration number after 6 years because it couldn't be renewed and reinstated after that. So that is the one amendment, and then the additional amendment is what I talked about previously, where we're talking about participating for ASWs, participating in the law and ethics exam each renewal cycle instead of having to pass it in order to renew. That's incorrect. So we've cleaned up that language with this proposal. So I'll open it up for discussion.
So I just noticed that this quickly. So page 174, okay, so that's the, what would be the easier way to do it? So it's the second page of the legislation, and the proposed language is section C, the new proposal of C, and the second edition, and has passed the California Law and Ethics examination. So will that actually be participated also?
So it's kind of a twofold problem. That section, it was, LCSW law is written a little bit differently so that when we wrote this, I think it got a little bit muddled. Number 4, the first sentence above, is the incorrect statement that's talking about obtaining a passing score on a registration in order, or on the law and ethics in order to renew a registration. So that's been struck, and we've added there participate in the California Law and Ethics exam. And then going down to C, where you're seeing it, the requirement to have passed the California Law and Ethics exam actually belongs in section C, where we're talking about getting a subsequent registration number. They have to have passed it. So
oh, I see.
we're making this I'm rewriting it so it follows more the same formula of what the other 2 licenses did. It didn't follow the same formula before, and that got us into some problems. So.
Right. So that's a little inconsistency. Maybe we can, clean it up down the road.
So we're cleaning it up here. Yeah.
Yeah. Okay. Okay. Any board members' comments? Okay. Public comments? Like, the new language is clarified? Great. Okay. I need a motion.
Okay, so the motion is, hold on one second.
Oh.
On the exact language. Did you want to make it? I need
Go
to
ahead.
move it. How come it's not moving up? Oh, no, this is the attachment. That's, I'm like, oh. So can I look at yours? Sorry. It's to direct staff to Thank you. Oh, perfect. So to direct staff to make any discussed changes, which we've done today, and any non-substantive changes, and bring to the board for consideration as a legislative proposal. Thanks.
So, Samara and Christine. Okay, so we need a vote, roll call.
All righty. Christina Wong?
Yes.
Deborah Brown?
Yes.
Dr. Christine Whitlisbach?
Yes.
Samara Ashley?
Yes.
Motion passes.
Thank you very much. So the next one, shall we proceed to the next one? That will be the discussion of examination rescoring.
Okay.
And it's Christy.
Yes.
Thank you.
Thank you. So we're looking at a possible regulation change when a candidate requests a rescoring of an examination. Right now, our statute allows the board to charge a $20 fee to rescore an exam The fee is also listed in the regulations, but there's no definition of an examination rescoring. This has been in our law for a very long time, and it has its roots back when we were doing paper and pencil exams. Now everything's done electronically unless you have a special accommodation for a disability that requires paper and pencil. Any of our exams that are administered electronically are automatically rescored. There's a process for that. There's also a process for candidates to appeal and express concerns to the board that we will investigate, and there's no fee to do that. So what we're doing currently is that for a paper and pencil exam, if you have that accommodation, you can request, pay the fee and do the rescore, ask for the rescore, and we'll do that. There's no point in paying $20 when you've taken this electronic exam. So what we want to do is make our regulations match that and define that. So that's what this proposal would do. It also would strike the regulation that talks about the fee because it's already set in the statute. So there's no need for that. We might as well get rid of something unnecessary. So that is that.
So we really are not doing any paper and pencil examination anymore?
Only if you have a special accommodation.
Ah, right, okay.
And prior to the release of the exam score, the exam is rescored twice if you're taking it electronically.
Okay, very straightforward. Oh, I need to make sure that all comments taken. Any comments from the public? And board members, staff? Okay, we're ready for a motion.
Make a motion to direct staff to make any of the changes that we've just discussed and any non-substantive changes in the board for regulatory proposal.
I'll second that. Any other discussion? Okay.
Christina Wong?
Yes.
Deborah Brown?
Yes.
Christine Whitlisbach?
Yes.
Samara Ashley? Motion passes.
Thank you. So the next item, discussion of application abandonment criteria. Also Christy.
Yes,
Thanks.
thank you. So we're going to be looking at, would be another possible regulation change. What abandonment means is a situation where you have an applicant, they've submitted an application, it's not been approved yet. We're saying that there's something that we need from you to finish your application. Or it might also be someone whose application has been approved, but they're in the exam process and they need to take the exam within a certain period of time, or they're considered to have abandoned their application. So right now, our regulations specify the circumstances, the exact circumstances under which an application would be abandoned. We had to change these regulations a little bit with the exam restructure, and we need to look at some more changes to this to make them clearer. And and this may tie into some of our other discussions, if somebody abandons their application, they have to submit, if they want to reapply, they have to submit a new application, fees, and meet current requirements if they still wish to pursue the application. So that language is in our abandonment section as well. And we licensing lets them know what exactly they need to resubmit, because it might just be a few months. We don't necessarily make them submit new transcripts and that kind of thing, just depending. It's case by case. So what the changes that this language would do is, sometimes we have people who don't understand what abandonment means, and it could mean if you abandon your licensing application, you're going to lose hours that are older than 6 years. So we want to move the very last line of this regulation to the very top that talks about the consequences of abandonment and that they have to meet current requirements. We want to delete subdivision A, which talks about an application not being completed by an applicant within 1 year after being filed, because the next subdivision really deals with that, where it says the applicant does not submit information required in order to correct deficiencies specified in a deficiency letter within 1 year from the date of that deficiency letter. Anything that's not complete in the application, which A talks about, is going to be specified in the deficiency letter. So A is really redundant. Then the new subsection B would encompass all of the possible situations where an applicant doesn't take an exam in time. So the situation is, Once we say, you're cleared to take the licensing exam, and we're talking about people who have actually submitted their hours at this point, you're cleared to take the clinical exam. For an out-of-state applicant, it could be the law and ethics, because they may not have been in our system and they're going straight to applying for licensure. So what we're saying is, we approve your hours, you've got a year to take your required exam. If you fail that exam, you have to retake it within 1 year. The other situation is if you pass the law and ethics and you've submitted your hours, again, I want to be clear on that, it's not for registrants. If you pass the law and ethics exam, you have to take the clinical within 1 year of passing. So that B would encompass all of those situations. The last piece we're not changing, which is if they don't pay the initial license fee within 1 year of passing their clinical exam. That's that.
Any comments? I think it really adds some clarity also, to delineate what it means by, the abandonment and, yeah. So this is good.
Ready for a motion?
Public comments? People love that language. Silence is good, so. Okay. Yeah, right.
I do like input.
Well, silence sometimes means that no objection, so, yeah. Okay, so I'm ready for motion.
Okay. Move to direct staff to make the changes we discussed today, any non-substantive changes, and recommend to the full board as a regulatory proposal.
And Deb, second. Any other discussion? Okay.
All right,
Ready.
Samara Ashley,
Yes?
Christine Whitlisbach,
Yes.
Deborah Brown,
Yes.
Christina Wong.
Yes.
Motion passes.
Thank you very much. So the next one also belongs to Christy, is about the discussion of LEP experience requirements.
So this one's quite a bit more involved. I just want to say we're not making any hugely significant changes, but there are some things that are significant. A lot of it's just clarifying or codifying current practices. And, we don't talk about LEP a lot. We haven't touched this law in, I can't tell you how long. So I want to kind of go to through some basics about it, just so that, to refresh everybody. So right now, our LEP applicants, they have to have a total of 3 years of experience to qualify for licensure. 2 years, everybody has to have 2 years of full-time experience as a credentialed school psychologist. So you have to have your credential and doing that for 2 years. It does not have to be supervised. You're working in a school setting. Okay. Then their one additional year can be either, and in this memo, category B or C. They can either have 1 year of supervised experience in their accredited school psychology degree program, or 1 year of full-time experience as a credentialed school psychologist and have some, what's implied supervision? It says under the direction of an LEP or licensed psychologist. And so as you can see, it differs significantly from our other professions. So LEP law doesn't require necessarily all the experience to be supervised. They don't have to register with us in any way. They just apply for licensure once they've completed this, and they verify their experience. They do have some supervised experience, but they're in their 1 year. And our law doesn't specify who must supervise for category B. But the Commission on Teacher Credentialing does specify who must supervise during the degree program. So what they require, and I've attached a summary of their requirement, or a printout of their requirements on the attachments, that it has to be supervised by a credentialed school psychologist who has at least 2 years of full-time experience. And they have to actually do 1,200 hours of supervised experience in their degree program, and they have to do a written plan for supervision. Is there any questions about that at this point? Okay. So I want to step back a little bit and talk just in general about what school psychologists do. Because it's, our LEPs and school psychologists, it's a little more broad maybe in some ways, and they do a little bit different things. So other than, providing counseling, they consult with school staff. They develop intervention programs for not only individuals, but for groups of pupils. They coordinate resources. They're members of interdisciplinary teams quite often, and they look at the effectiveness of instructional and behavioral interventions. That was just kind of a step back. It's, as we're thinking about this. So, fairly recently, we were looking at all the documentation and things that we require as part of our licensing applications. You might remember I came with a pretty detailed list that we're putting into our regulations of you have to submit transcripts, you have to do this and that. So while I was looking at that, when I looked at the LEP section, there were some things about it that were confusing, and I talked with staff and I found out some things that we're doing that we need to get into our regulations. They're things that have been done since before I was even at the board. So we're talking long history of experience here. And I think they make sense. It was, back, 20 years ago, our law is a little more general, and we had to interpret some things, and that's kind of where all this came from. So when you look at those categories, A, B, and C on the prior page, staff has informed me that historically we've evaluated their experience on a school year basis, which is about 8 months is what they look at. And that makes sense. Our other professions require 2 years. If you look at 8 months times 3, that's about 2 years. So, but it's not stated in our law. So I feel like that should be clarified. And if you feel differently that it should be full 3 years, then we can talk about that. The other thing is that the law talks about full-time experience, and so we've equated that to 32 hours a week. And then again, that's not stated in the law. It also talks about, we also accept part-time experience that's equivalent, but the law, again, doesn't go into what that means specifically. The law also doesn't specify the type of documentation necessary to verify the required experience. So I'm going to we'll go into one by one of what we may want to do, and then we can talk about, if we want to go, what we want to go with in terms of numbers and things. There's a problem specifically with category B, which is the 1 year of supervised experience in an accredited school psychology program. The Commission on Teacher Credentialing, like I said, it requires 2 years of full-time experience for the supervisors and to be credentialed. But their requirements don't address dual relationships or require that the supervisor's credential is current and valid and not under suspension or probation. And it's a similar thing for category C. Although that's not directly supervision, it talks about that experience being obtained under the direction of an LEP or licensed psychologist. But again, it doesn't address the dual relationships. Things like you can't be related to your supervisor, things like that. And it doesn't require their license to be current, valid, and not under suspension or probation. What I'll do is I'll go one by one, the changes that we're looking to make, so the first one would be we're just improving the readability and some clarification. So we're dividing the regulation into 3 subdivisions, A, B, and C, each of which would pertain to the categories A, B, and C, because they're each a little bit different, and some clarification would be really helpful. We're going to specify the required documentation to verify experience in coursework. Then looking at the requirements for individuals overseeing the experience. So what we would propose adding is that they possess a current and valid license or credential that was not under suspension or probation during the time the applicant was gaining experience. We would require them to not have provided therapeutic services to the applicant, and that would only apply to category C because you don't have credential holders providing therapy outside of a school setting. So that's not going to apply to school psychology. It would just be the licensed psychologists. The supervisor can't be related to the applicant or not the spouse or domestic partner, and they do not have a personal or business relationship with the applicant that undermine the licensee's or credential holder's authority or effectiveness. And I pulled this out of our other licensing laws so that the language mirrors. there any feedback on that piece?
Go ahead.
Hi, I'm Chris Jones from the California Association of School Psychologists. Sorry if I'm my first time at this meeting, so if I don't know the protocol, please forgive me. I just have a couple of questions. When you are talking about breaking the 3 categories down into 3 separate categories, so you're taking away the or and making 3 ands, are we talking about making a longer experience before allowing to apply for the license?
No, what I'm talking about really is, right now the law is kind of written in one big chunk, and what I want to do is just for clarity purposes, break them apart. So it would still be the 2 years and one or the other 1 year. So it would still be 3 years in total. It's just kind of breaking them up so that we can get a little bit more specific when we're adding things like, some specifics about the supervisor.
Right.
Yeah.
No, that's fine. I just didn't, the way that I was reading it, it made me think that when you wanted to make 2 ands versus the or, and we're getting into the semantics again, that it would add an additional year. It's the 2 years and the internship year and the year of supervision, or the year under the LEP.
I see where you're coming from now. I see where you're coming from. So if you look back at the Business and Professions Code, that's where the very basic requirements are set.
Right.
And then the regulations are just saying, okay, if you have, so the statute is still going to say 2 years as a credentialed school psychologist and one or the other.
Okay.
So this is just saying if you have this is what it has to look like. Yeah. So.
Oh, perfect.
Okay.
And then, can you explain to me a little bit about what the statute or does not have a personal or business relationship with the applicant, which would undermine the licensee's or credentials holder authority or effectiveness means? What is that?
Can I punt that to Kim? Because that would be where we get a complaint, and we would, that's a little bit, maybe a little bit tricky to explain, give some examples of that.
So a situation in which, not typically, but frequently what we see in the other professions is that maybe the intern has set up their own nonprofit or business on the side, and they're employing a fully licensed individual. The fully licensed individual is then asked to provide supervision to the owner of the business, the intern, and that's a very conflicted relationship because you have the intern being the employer of the licensee, but then the licensee is supervising the intern, and so there's sort of an inherent conflict with both of those relationships.
Becomes a dual relationship. Okay. Makes sense.
And it looks like that section of it is modeled after the MFT and the LCSW law, in describing the supervision relationship. So it's really not really new. It's been that section of the description has existed in the other part of the licenses.
Oh, no, that's fine. I just didn't completely understand what it meant. Thank you.
That's it? Oh.
I think for now, yeah.
Okay, all right.
I'm sorry. I apologize. Yes.
No problem. You're
Yeah.
doing good.
Yeah.
Thanks. Leah?
A quick question. Are they already submitting documentation anyway? This won't be a new thing for them? Is something that's been in practice but just not codified?
Well, the current law doesn't require they possess a current or valid license or credential. We do check.
No, I think I'm referring to the documentation. You're changing the language
to
to
right.
require documentation.
Yeah, it's going to mirror what we currently do.
It is.
Exactly.
It's what they're doing
It's
anyway.
nothing new. Yeah,
good.
you got it.
Okay.
Jonathan?
So I actually have a question, and it may be for clarity. So the regulation going to state that they can still have 2 years of unsupervised experience and then the 1 year supervised experience from school. And the requirements are for that 1 year in the academic setting while they're in school. Am I understanding that correct?
Yeah, you understand that correctly, yes. Because it can be the 1 year in a school or 1 year supervised outside of school, is one or the other is that third year. And those are the two that we're talking when we're talking about supervisors.
So my question is, and maybe it's clearly my own ignorance, could you help me understand why there isn't the need for LEP students in the licensing track to be supervised by licensed staff after only having had 1 year of supervision while in school, because that's clearly not consistent with other licenses across the board?
So the Commission on Teacher Credentialing is who they get their credential from that allows them to start practicing in the schools. And so there's a whole regulatory scheme for them outside of the board that oversees all of that.
Typical school psychology programs are 2 to 3 years, which include a practicum year, 2 practicum years, in addition to a full year of full-time supervision. Full-time work within a school under supervision of both the university supervisor and an on-site supervisor. So, and if you look at the programs, they differ. The minimum in California is 1,200 hours for the 1 year. It's those 2 other years that differ in time depending on whether the program is approved by the National Association of School Psychologists. So they would do a first year of what you guys would call the practical year in the MFT program, where you've done your coursework and you're doing 1 day a week of supervision, of observation, those sort of things. Second year, you've got 3 days a week where you're in schools doing the services of a school psychologist under the direct supervision of a credentialed psychologist in the building, in addition to the university supervisor. And then there's a 3rd year on top of that.
I mean, and I don't know how much more I need to. So my thought about that is, I'm just wondering, because psychoeducational testing generally disproportionately impacts people of color and poor people so significantly. And like, my concern would be, and this isn't for the board, I guess I'm just trying to air it, is that a student who may train in a locale that is not very diverse, and then they go into an urban community and begin to do psych ed testing, and now they're testing racial groups that they have no experience with, there is no supervision to ensure that there is sort of competent care and that people aren't being sent into a particular educational track that they may not necessarily need. So this is more of probably a larger issue, but I didn't know if that's something the board oversees, but my understanding is that that is not what we do, and so.
Right. The Commission on Teacher Credentialing, and they may have there may be, something in their coursework that's required, or I'm not sure exactly, how that works.
There's very specific training on working with different populations and cultures, and there's very specific rules and regulations that we have within our profession about testing students of color, students of different races, and it's a big discussion that we have and a very hot topic.
And hopefully it's ongoing, because I know the disparity still exists.
It's very much ongoing.
And it's, so for now, we're not changing the practice.
Right.
So we're basically, thanks for the education, because I think the information is important for us to know what those supervised experience means.
Right.
At the same time, for this particular bill, we're not really changing anything, not like the supervised hours or the years, and we just need some clarification, in the law, how it counts a calendar year and things like that. Yeah.
I did have another question about I don't know if this is the time to bring it up, about the number of hours per week. So how did you come up with 32? I guess
That's a great question. I guess that's been the historical number, and I'm going to talk about that a little more.
Okay, I didn't know
minutes.
if this is the time or not. Go.
Almost.
Stay here.
Yeah.
Okay.
Yeah, we'll just stay there.
All right. Seatbelt on, ready to go.
So it looks like we can move on,
Yeah.
Yep.
So the next would be, we need to define what is a school year. And so what I did was, I looked at the California Education Code, and it requires, it's a little bit muddy, but it looks like right now, because there's been some modifications, as you know, Deborah, it looks like it's 175 days or more, which equals about 35 weeks. Staff currently uses 8 months, but that doesn't have a basis in any law, so I would like us to be in so. And using the assumption of 32 hours, and like I said, we'll discuss that in a minute, but if we use what we're currently doing, which is 32 hours a week or more hours a week, that full-time experience for one school year would be about 1,120 hours. So that's how much you would have in one school year. So I feel like that is, using that standard puts us pretty close to, maybe what we do with the other license types.
Deb?
Typically, you see 180 days to 186-ish. When there was a big budget problem, the governor allowed us to go all the way back down to 170, 175. But since that time, it's back up again, and you can't go that low again.
I have to look a little closer because there was a difference between elementary and high school.
Yes, but
So I went with the lower, but I can double check that.
I'm probably on the average, it's going to be somewhere between 180 and 186 days, somewhere in there.
And what we could do is just, instead of specifying it in our law, maybe what we do is just refer to the education code, because that could change.
I would do that just because, depending on the budget, then there's allowances for school districts to cut days because of money. And we got all the way down to 175, 170. Teachers took furlough days, and so the students weren't in school. And then usually by the hour, your school day is only about 6 hours long. So, if you take out lunch and you take out recesses and you take out all of the other good stuff, it's not that long. It is a relatively short, it's not an 8-hour workday. And it's an 8-hour workday probably if you're supposed to get there at 7 and you get to leave at 3:30, but a contracted day is pretty much just around 6 hours or so, where you're actually working. Okay. So I think it's interesting, and I think something we have to look at, because when I look at the LPCCs and I look at the other ones, are they based on full-time work and a 40-hour work week? Well, teachers, we don't work a 40-hour. We do, but we don't. Our contracted hours are not a 40-hour work week, okay? Because that's not the time we're sitting in school teaching class.
So if your employer were to verify your experience, it might be, if we asked how many hours a week, it could be a lot. You could be full-time and be 30 hours maybe. So that plays into our next, we might as well go ahead and talk about that.
It goes by school district, by what they contract with the union. It's negotiated, your contracted day.
A lot of the school psychologists work more than the 175 days. They're contracted 180, 190, that go beyond when kids are there. And to your point, excuse me, I call the 6 hours bell to bell, right? The school psychologist is typically, 7 to 8 hours a day. When I brought this up, we had a committee meeting at our convention, and we were looking over some of these changes. And I said that 32 hours a week, they all laughed. And they said that I've never met a school psychologist who's worked 32 hours a week.
But it's more, you're saying?
It's usually more. It's probably closer to 40. But to your point, though, there is the contract and what it says within.
And I think we have to be really, because anyone can say, well, yeah, I work on weekends and I do all of this other work. So I think that from that point of view, I think we need to look at a language and stick with the language. And I think that if you were hard pushed, it would be contract. By contract, because you do stay after school,
well,
but then you're having these IEPs and these 504s
until
5 o'clock at night.
Yeah, the biggest part of it is the meetings that occur before and after school, and then you're seeing the kids during the school day. So those are required times for psychologists to be on campus. And if you do look at contracts, for example, I live in Santa Clarita at the William S. Hart High School District. They're contracted 8.5 hours a day. And, the half-hour lunch or whatever. But, that's what they are. But, yeah, I think it would be important to look at some different contracts in school districts to see what they determine full-time is. It's really only going to impact, in my opinion, from the LEP perspective, it's only going to impact those that aren't full-time. So, if you say you're full-time, it doesn't matter how many hours that is. If you've worked 2 full years, you've worked 2 full years because your school district can verify that. But if I'm a school psychologist, use 32 hours, that's 6 hours a day? If I'm doing the math, and I'm contracted to work 7 to 8 hours, or let's say 7 hours a day, then, and I'm an 80% person. So school districts go by percentages of time. So you work a day versus a number of hours, and it's a professional day. Absolutely. So if I'm applying for my LEP, and I'm an 80% person, and you're giving me 6 hours a day, the board is giving me 6 hours a day, but I work 7, that's 175 hours I'm losing. So I do think it would be important to get a more accurate number. I mean, I don't know if that means to survey school districts and see what different contracts are.
But I think the important part is to stay with a certain language. So if the board lands on contracted hours or contracted days, not what the average, I mean, I don't think that we have the resources to go out and do an average survey on what special ed teachers work. And we're talking about a very small population, and the ones that do the 190 days, some up to 200 days, are usually administrators, and they have a whole different contract. And so it's, I mean, they're not in the
It
union.
depends on where the psychs fall, because we fall
Right.
under teacher districts, we fall under management
Right.
contracts under some districts. There's no rhyme or reason.
That's
well,
why you
I'm
could
sure.
be up to 200 days.
Right.
If you're under management, if you're
Right.
under admin.
Yeah.
So Kim has a comment, and then Leah.
No, I didn't have a comment.
Oh, I thought you were going to say something. Leah, go ahead.
I would recommend that we not try to make this like the other licensees and put hours in. I would recommend that, does the current language work for full-time academic year as opposed to annual year? And because academic year is defined by each district. So just that they're working full-time equivalent in an academic year, and just forget about the hour piece. It just seems like it might get too hairy.
Well, in that case, what we would do, if we said we would leave it maybe up to this, what we would have to do, if our law didn't specify what full-time was versus part-time, we would leave it up to whoever's filling out the experience verification form to check a box. Is it full-time?
Yes.
Was it part-time?
And then did they meet the whole academic year? Did they not do the whole academic year?
Right.
And if you have the
We asked for
supervisor
the dates.
certify that, then that should take care of protecting people.
That is one option. Another option might be to specify it on the low end, because when I did a calculation, if we use 32 hours a week, and we did that over the entire 3-year period, it would come out to 3,360 hours of experience, which is pretty significant. It's over and above the other license types.
Yeah.
We could even go down to 30 and be okay, so.
What's the advantage of putting a number?
Well, we don't necessarily, of putting in a number, well, I think in my mind and the evaluator's mind, maybe you have, and maybe this isn't accurate for the profession, part-time, how part-time are you? You 2 days a week? How full-time are you? So you want to make sure that the amount of experience that they have is, satisfactory, or meets the intent of the law. So, but if, and now that I'm thinking about it a little more and hearing what you're saying, it's probably highly unlikely you've got a school psychologist who works 1 day or 2 days a week. I mean, but maybe, I don't know, maybe they do in some really tiny rural areas. So,
I'm also thinking the reverse. Then if you're putting these hours and then somebody gets their hours in 2 years instead of the 3 years, then do they get to be done early? Or, you know what I mean? And
I didn't want to specify overall hours. I wanted to specify we would leave full-time in there and then define what full-time means. So it would still be a school year, still be on a full-time basis, but what is full-time? Because then if you're not full-time, then you're part-time, then we would prorate that. We have a calculation that we would do.
so maybe what you say is full-time based on their contract, and that if not full-time, then for them to demonstrate, or for the supervisor to specify how many hours a week that is. Right, it's just, it's so varied.
Mm-hmm.
Absolutely.
Just a note, we don't have very many registered licensed LEPs. So if you can get a hold of one, I mean, that's like a gem.
4.
That's like a diamond in the sand.
I'm right here.
I think you are.
We have a lot of people going through our program who are LEPs who are going to add the LPCC to their LEPs. So that we have a lot of people in this
But most
situation.
of them in schools are not registered, and they're not licensed. They've got the credential from the CTC over there. And so usually you find people who have the license are typically the admins, and they're the ones that are doing the supervision of the ones that are sitting over there that only have the CTC credential. And so there's a competing, we're overlapping and competing with one another because the CTC does their own thing with all of the special ed teachers and those programs. And if you want to actually be a licensed educational psychologist, I know at the university I work with, then you go over to the psychology department. But if you just want to be a credentialed special ed teacher, you stay in the ed department. So there's all this overlap depending on where you land, and then school districts, they'll take either. They're so desperate for special ed teachers, and they're just, when we look at our numbers, there's only like 500.
No, we got almost, it's over 1,200.
What, how many?
1,200 LEPs.
But in the state of California, that's
I could be
about right.
Yeah, but that's okay.
To me, very small.
I thought we were at 3,000.
You might be. I don't know. I don't remember off the top of my head. I don't. LEP, what do we got?
Pretty sure we're close to 3,000.
I mean, comparatively speaking to the number of special ed teachers out there that are credentialed with CTC, it's very small.
Right.
Very small.
I do like 2,080. You lost your, yeah. But probably 60 more, right?
Right. We're seeing more and more school psychologists who are interested in getting their LEPs every year. The number's rising. I do the LEP workshop, the test prep workshop for CASP, and over the last 3 years, we've had more and more people attend. We had over 70 people at our last convention came down, and a lot of people.
We need them. There's a real demand out there for your license.
I like Leah's idea.
I like Leah's idea. The only tricky part about that is if we're determining what is equivalent part-time experience, what do we base that on?
Well, I'm wondering, so you talked about, repeat your, here's what I was thinking. If we define full-time as working more than 30 hours a week, that's full-time, and anything less than that is considered part-time?
But isn't it determined by the contract?
And it could be,
right. So 30 might be part-time for somebody else. So I'm just thinking you say full-time according to their contract, and then if it's not full-time, what percentage based on the contract are they working? And you calculate it based on the percentage.
That's how school site contracts are done, is it's by percentage. You're 100%, 80%, you're 1 day, 2 day, 3 day, 4 day, 5 day.
So if you were part-time, you would be like 50% or less, or 60% or less?
It's done by 50%. You work 2.5 days a week.
Okay.
So
you could be full-time and working 4 days a week.
No, full-time
that's
full-time is 5 days a week.
Full-time is 5 days a week. Okay.
Yeah, you can be all over the place in 10 different schools and all of those things, but
They're at 50%, they have to go twice as long. If
Right.
they're at 25%, they have to go 3 times longer, right?
So will the licensing unit staff be okay with, looking at that clause and, convert those percentage into hours and?
I think so. So what I'm envisioning, the form would have a checkbox for full-time, and then if it's part-time, they would mark that box and put the percentage. So if we told, maybe
The 3 years might be different, right? 1 year might be full-time and another year might be 50%.
Exactly. So
Right.
staff would know that, full-time equals 100%. And if they get anything with less than that, I think that would be pretty clear. I don't have any staff, fortunately. They all left.
You have to be good at math to figure out how to add those percentages.
Yeah, and they're already doing that because we're using 32 hours a week, so they're already doing prorating and things like that. But I think, and it's percentage, that would be pretty clear to use a percentage for part-time. That might be even simpler than what they're doing now.
Makes absolute sense.
Yeah.
Okay.
Okay.
That's good to know.
Sounds good.
So I would need to rework this language a little bit as far as that goes. So that would need to come back to this committee, I'm thinking, so.
Do you want to come back to the committee and relook at it?
Yeah,
Okay.
I think that would be our best way.
So in that case,
to go.
do we need a motion? I don't think so. Okay. Thank you very much. Thank you so much for your input. Yeah, this is
Yes.
awesome, and Leah too, yeah.
Very good, helpful
And
information.
Yep. Wonderful. So we have one more, just one last bit of discussion, and then we have one report. So would you like to push through it and?
It's going to be super quick. this next
Super
one.
quick. Oh, let's do it.
All right.
So Christy, go ahead. FE for subsequent PCCI registrations.
Yes. So as you know, you can get more than one registration as an associate, as they are now called. And so our first PCCIs are reaching their maximum 6-year time span. They'll be reaching that in January. So as we were developing the application to get your subsequent registration, we noticed that the way the fee was written in the LPCC law was different from our other licensing laws, and it talks about the fee for initial intern application. So it doesn't, that kind of constricts what we can do a little bit. So we just need to clarify that this fee is for initial or subsequent intern numbers. The other thing that I need to point out to you is that this section of the regulation still uses the word intern, and that needs to be changed to associate as well.
So the language is actually really straightforward, too. It's only strike the couple words and
Yeah, and
change
just
it.
say the fee for associate, professional clinical counselor associate registration application shall be $100. So that way it applies to both.
Okay. Any questions? We're not changing a dollar, just changing the language to clarify. Okay. Any discussion, board members, public? I need a motion. I'll make a motion. I will direct staff to make, well, there's no changes, and so we'll bring this to the board for consideration as a regulatory proposal. And so Christina and Christine, and any other discussion? Okay, we're ready for vote?
Christina Wong?
Yes.
Deborah Brown?
Yes.
Christine Whitlisbach?
Yes.
Let's note that Ms. Ashley stepped out for a moment. Motion carries.
Thank you very much. So the last, well, not quite. The next agenda item is the review of board-sponsored and monitored legislation, and that's Roseanne.
Okay, so the deadline for the governor to sign all bills on his desk was October 15th. So I'm just going to go over the bills that, as of print, an answer about them were not available yet. The governor did end up signing our omnibus bill, SB 800, so that will go into effect January 1st. He also signed AB 1188, which is the Health Professions Development Loan Repayment. That's going to increase the fee that our licensees pay on renewal that goes toward the Mental Health Practitioner Education Fund fee from $10 to $20. It also adds LPCCs to this program, so they'll pay $20 now, and they'll get to participate in the competitive loan grant program. Loan repayment grant program. This becomes effective July 1, 2018. We had asked for a delayed implementation date so that we can make all the behind-the-scenes breeze changes and send out application notices that are correct. So you'll see that later this year. AB 1591, the Medi-Cal federally qualified health centers and rural health centers that would have allowed LPCCs to be hired in those, that bill was vetoed by the governor. And so that one did not go through. And then one other one that we're likely to hear about that I'll point out at AB 89, requiring licensed psychologists to have suicide prevention training, 6 hours of training, was signed by the governor. That affects psychology board. That is it.
And any questions about the recent bills? Okay. So thank you so much, Roseanne. So the next one is suggestion for future agenda items.
Next, you have the reg proposal, update on rulemaking activity.
Oh, sorry. Okay. Oh, yeah, the rulemaking. I missed it, sorry.
That's okay.
I apologize. So Christy, sorry about that.
No worries. I want to start with just letting everybody know our English is a second language, providing time and a half for qualified applicants. That did pass and took effect October 1st. Our application was up on the website as of October 2nd, because that's the Monday. So, so we're already getting lots of applications from what I understand.
Great.
So in terms of our regulatory proposals that are currently pending, I'll give you the status on those. The advertising, that's the one that would deal with the intern to associate, and then the application processing, retooling that section of our regulations is currently in the final phase of the regulation process, as I mentioned earlier. So we are expecting that to take effect January 1st. We're monitoring that very closely. This other regulation, one of the three that we've got going right now is does quite a few different things. It's the one that deals with all of our application requirements and specifying the documentation necessary, all of that. It also would require all of our registrants and licensees to provide and maintain a telephone number and email address to the board if they have one, and it would be confidential. And they would have to keep that current with us. We would also ask the same of applicants, which we already do. We're just putting this into our law. Another thing that we would be doing is requiring certain applications and forms to be signed under penalty of perjury, and dealing with situations, having some standard procedures when you have somebody who's supervised experience and their supervisor becomes incapacitated or passes away. How do we deal with that? So that puts a procedure on the law books. So this was approved by the board in March, and it's in the new initial review phase that's required by DCA, which can take up to 4 months. So that one is getting close to being done with that. So once that's done, we'll publish it with OAL and get that process going. The last proposal that's pending has to do with enforcement. It's going to update our disciplinary guidelines and our uniform standards related to substance abuse. And there's 3 general categories that one would strengthen certain penalties. We would update the uniform standards in responses to some statutory changes in the Business and Professions Code, and we would just do some clarifying language. So this was approved by the board in February 2017, and it's in the new initial review phase by DCA.
Just have to keep watching.
Yes. Keep it moving.
Thank you so much, Christy. Okay, finally, it is suggestion for future agenda items. Okay, public comments for items not on the agenda? That's it? Okay, quiet. So silence is good too. All right, so the time now is 12:22, and our Policy and Advocacy Committee meeting is adjourned. Thank you so much, and see you guys in November in our full board meeting. Couple weeks.